what's inside your eyes. Can you feel the rush? Closing the gap we made. Oh, how I miss your touch. Push through the ceiling now. We can raise it up. Am I dreaming? Come feel what I feel. Come see what I see. Drop your guard and let the night take over. Come feel what I feel. Come see what I see. Drop your guard and let the night take
All right, we are back on the record. The attorneys are present. Mr. Miu is present. We are outside the presence of the jury. The jury was summoned in at 8:30, so they are probably assembling as we speak, but this gives us some extra time to wrap up some of our work. I do have a few things I want to address before we get back into the jury instructions. I meant to make a record yesterday about the sidebar. During Mr. Miu's direct examination, Mr. Nelson asked questions about nightmares. There was a state objection. We had a sidebar. It was my judgment that since Mr. Miu's credibility was being attacked, Mr. Miu's life experiences dealing with the traumatic events on July 30 were relevant. So I limited the scope of the inquiry to the fact that Mr. Miu was having nightmares, that they were about July 30, 2022, and that he sought out treatment or counseling for them. I did not allow the defense to get into what the medical treatment was, including prescription medication that he may have been given. I also instructed the state that given the objection and given my ruling, that the state would not be permitted to make arguments that Mr. Miu's experiences should be discounted because there's no evidence of a medical provider, a psychiatrist, psychologist, or prescription medication because they had objected to that evidence. So that's my summary. If anybody wants to add to it, you may do so.
That's my recollection, Judge.
Yes, Judge, just to make it clear, I wanted to, as an offer of proof, I wanted to ask Nicolae about how his body responded to those nightmares. That is, when he woke up, what was his body feeling? Was he chills? Did he have sweat? Was he shaking? If I had asked those questions, I would anticipate that he would have told me all of those things would have existed. I again think that that would further support his claim that the nightmares were real. Secondly, I wanted to ask him about the treatment, and I expected him to testify that yes, he saw a doctor and a nurse, mostly a nurse in the jail, and that he received a prescription for prazosin, which it's his understanding and confirmed by my research that that is a prescription for PTSD-related nightmares. And so again, as Your Honor somewhat articulated, it's our position that if the state attacks his credibility on that, I should be able to get that into evidence. It's our position that since they're attacking his credibility in general, anytime I can have his credibility supported on relevant matters, I should be allowed to do so. Your Honor gave the ruling that Your Honor articulated.
Right. And the attorneys do have the ability to rehabilitate the credibility of their witnesses. I just put limits on the extent that we were going to go into it. That's largely how I arrived at my ruling. I'll also note too that we've had a number of other sidebars where we didn't make records. Everybody has the opportunity to make a record if they feel one is necessary. It's been my recollection that most of these substantive rulings have had records made in close proximity to the time of the sidebars. Others, I may have made rulings on form questions, foundation questions, given the attorney's direction to move in a different direction or approach a problem from a certain perspective. I don't think they were substantive in nature. It was more technical. I think some of the other sidebars had to do with the attorneys putting me on notice about things that are likely to occur or may happen. But I don't remember any other sidebars that involved the inclusion or exclusion of meaningful substantive evidence over the objection of one of the parties. Anybody remembers something that they want to make a record of, you have an open invitation to do so. I also want to circle back to exhibit number 24. Yesterday, there was a request to seal a trial exhibit. Neither of the attorneys have provided me with any law authorizing it. And unless you do so now, I conclude that you still do not have supporting authority. As a judge, I
believe yesterday I articulated, I think exhibit number 24, I would just note chapter 950. I appreciate it's probably not my space to make that argument, but I will nevertheless. And chapter 950 involves the dignity of human beings, in particular victims. And in my opinion, the photos I think we're talking about the photos.
Yes.
Right? Those photos being made public is contrary to respecting the dignity of those people that have that right.
I understand the thought and the sentiment. In a way, as a human being, I agree. However, as a judge, I have to follow the law when it comes to sealing records. And judges are very restricted, at least in Wisconsin, about what records can be sealed from the public. And the authority is defined specifically by statute. Things like juvenile records, trade secrets, social security numbers, pre-sentence investigation reports, psychological studies. Things like that are all defined in statute that a judge either is permitted to or is required to seal. Judges do not have broad authority to seal records that the judge thinks would be appropriate or to protect the interests of individuals, unfortunately. So because this is a trial exhibit, it's been received into evidence, because this is a public trial that does not involve a enumerated statutory basis for sealing, I don't have the authority to do so, even though I may prefer to do so. I simply just don't have the authority. So the request for sealing is denied on Exhibit 24. I provided the attorneys with a printed version of all of the proposed verdict forms. Did anybody have any objections?
No. I don't.
Okay. So those will stand and be submitted to the jury. Is there anything else you want to address before we get back to the jury instructions? Okay, hearing none.
Actually, can we approach quick, Judge?
Yes. Have them printed. We left off at 1072, the attempted crimes for counts 2 through 5. Mr. Nelson, you had a lot of objections yesterday that applied to 1017. Those same objections would apply to 1072 because same issues exist in both instructions. So I've noted all of them for purposes of preserving the record. Are there other matters that you want to address in 1072?
Yes, Judge. in 1017 as well as in 1072 regarding the matter of second-degree reckless homicide on page 10 when you're talking about the homicide, and on page 20 when you're talking about the recklessly endangering safety, both in the second-degree matter. Both of them merely say the difference between first and second is the additional element. There is no mention in that discussion of second-degree reckless homicide, nor mention in the second-degree reckless endangering safety that it is the state's burden to prove beyond a reasonable doubt. I appreciate that it is in first-degree reckless homicide and it is in first-degree recklessly endangering safety. However, I think not including it in second to make sure and clear that the burden is on the state is in direct contradiction to the state v. Austin 349 Wisconsin 2nd 744 case that we've been discussing. This mistake, error in the instructions that were included is, I think, exactly what Austin says on paragraph 7, mentioning the jury instructions in Austin. Said, however, there was no mention of the burden of proof relative to self-defense. He talks about that in the context of recklessly endangering safety. And later on page 17, it talks about the standard instruction implies that the defendant must satisfy the jury that he is acting in self-defense. In doing so, the instruction removes the burden of proof from the state to show that the defendant was engaging in criminally reckless conduct. So I'd ask that on page 10 and on page 20 when discussing the second-degree reckless homicide and the second-degree recklessly endangering, that Your Honor add the words that I believe were added in other aspects, and that Mr. Miu was not acting lawfully in self-defense.
All right, the objection's noted. I am declining the request for the modification. Again, this comes from the pattern standard language from the jury instruction book, authored by the Jury Instruction Committee, committee of multiple judges who have studied these issues and have vetted appropriate language. The self-defense language appears in connection with first-degree reckless homicide and first-degree recklessly endangering safety. The jury will be instructed that one is not engaging in criminal reckless conduct if they're acting in self-defense. When we get to the second-degree versions of those offenses, the instruction makes explicit reference back to the wording from the first-degree offense, but simply tells the jury that the absence of utter disregard for human life, but the instruction for the second-degree offenses instructs the jury that they do not have to find the utter disregard for human life. So it's incorporating by reference the first-degree language. I think it is adequate. I think it is accurate. The attorneys will have ample opportunity to argue their respective points, including the importance of the self-defense being disproved by the state beyond a reasonable doubt. What's next?
That was the only additional request after reviewing the instructions, Judge.
Okay, and then last night we went through all of the other instructions. I'll give again another open call to additional instructions that you think, additional removal of instructions. Is there any changes, objections, concerns that you have to the jury instructions as presented?
Judge, regarding the excuse portion, I agree you can take that out. I'm not going to argue that in any way of provocation. So it was one of the bracketed instructions. It's on page 3.
Yes.
It's a single sentence paragraph.
It is removed. Anything else from the state?
Not on jury instructions.
Mr. Nelson?
No, Judge.
Okay. So I'll have the instructions finalized. My intent is to read before you argue. I'll also have the instructions displayed on the monitors so the jury can follow along. The jury will be provided with a few copies of the printed instructions in the deliberation room for their reference. Mr. Anderson, at sidebar, you said you had a motion to make?
Yes, Judge, I have a motion to strike one of the jurors. It was brought to my attention yesterday that during portions of testimony yesterday, one of the jurors was sleeping for an extended period of time and to the point of nodding off and then jerking awake. Both sides have a right to a fair trial, which includes juries that are attentive. I'm looking at Wisconsin Supreme Court case, State v. Novi, 346 Wisconsin 2nd, 289. It could, if there's a conviction, the defense could also try to argue that it violated defendant's right to fair trial. So obviously we want jurors who are paying attention to the evidence. So it's a two-step inquiry. One, it's a fact determination whether the juror was actually inattentive to the point of potentially undermining the fairness of the trial. And two, whether there's, why this is the appellate review standard, if there's prejudice as a result.
Which juror?
4021.
Judge, we don't agree. I'm not looking at them, so I don't agree with the factual basis.
Mr. Anderson, if you want to pursue the matter further, you'll have to provide a witness.
State calls Investigator Schultz.
Investigator, please stand, raise your right hand and be sworn.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Please have a seat in the witness chair. Mr. Anderson?
You've already testified, but can you state your first and last name?
John Schultz.
And were you present throughout testimony yesterday?
Yes, sir.
At portions of the trial, were you watching the jury?
I was.
Was there a specific point during trial period of time, I should say, where you noticed a concern about whether a juror was paying attention?
Yes.
What did you notice?
I observed one of the jurors with her head down and would startle up with her head on numerous occasions.
What kind of time period, if you can recall? Was it like 10-minute time period, half hour, longer?
About an hour.
And she was dozing off and appearing to startle awake?
Yes.
Multiple times?
Yes.
And from reviewing our jury list in our office, you believe that to be juror 4021?
Correct.
Nothing else, Judge.
Mr. Nelson?
What time did this occur?
I can tell you during what portion of the trial, sir, but I don't recall the time. I apologize.
Just yesterday this happened and you don't know what time it was when it happened?
Correct. I can tell you the portion of the trial.
Let's start from there. During which witness?
Lieutenant Hart.
And during Lieutenant Hart's direct exam or cross-exam?
It would have been during her direct exam.
And that was the, before the video or after the video?
during the video.
So was it during the exam or during the playing of the video?
I apologize, I think I'm getting confused. It was during the playing of the video,
Was it at any time other than during the playing of the video?
not that I observed.
When you made these observations, you were sitting next to attorneys representing the state?
Yes,
Did you make note to them, pass a note, give an elbow, whisper in an ear?
no, I told them after, or during a break.
So you made this observation while it was happening and you just, for lack of a better term, sat there and let it happen?
Yes,
Didn't bring it to the attorney's attention?
I did during the break.
When you say the break after the playing of the video?
I believe so, yes.
Was there a discussion about whether the state thought the juror was on the state side or the defense side?
No, sir.
What was that discussion? Who did you tell?
During the break, I just told the attorneys that I observed a juror who I believed was sleeping. But I noted that I believe she was sleeping and not just closing her eyes because of her head quickly coming up like you would when you startle from waking.
And did you, at the time you didn't, your estimate of the time is, fair to say, rough?
Yes, sir.
You, during the actual live testimony from Brandy Hart, you didn't make an observation of any of this, correct?
Yes, sir.
It was
Correct.
It was only during the playing of the video.
Correct.
It was only during a portion of the playing of the video.
Correct.
And your observation was just as you said, she had her chin tilted forward towards her chest at a couple of times during the playing of the video.
Yes, sir. Her chin tilted, eyes closed, and then head would come up quickly.
And when her chin was down and her eyes would close, would that last for a moment or would that last for 10 minutes or you don't know?
I was not watching her over 10 minutes, so I would say a moment.
Okay. So her chin would go down for a brief moment and then she would bring her head right back up. That's what you observed.
Yes, sir.
You didn't look over and see her chin down with her eyes closed and then look over and see her chin down with her eyes closed and then look over and see her chin down with her eyes closed. Agreed?
Sorry, I think I'm getting confused. Yes, that is what I would see.
I'm trying to figure out this, whether or not you observed her chin down, eyes closed, and she stayed in that position for some continued period of time, or whether you observed her chin go down, there was a startled moment, her chin would come up, or whether you saw something else.
I understand what you're saying now. So I was intermittently looking over, and during that period of time, there was times where I would just see her chin down, eyes closed. I would look back, and it would be that way, and then I would see her startle with her head up.
So you're not in a position to tell the court the length of time that you observed her to have her chin down with her eyes closed? Meaning,
Continuous? No, sir.
all right, you don't know whether that was for 5 seconds, 10 seconds, 10 minutes, you can't say.
Correct.
You just essentially noticed it a couple of times.
Correct.
And by a couple, 2 to 3, is that fair?
I'd say 4 to 5.
Okay. And of those 4 to 5 times, half of them were you saw her with her chin down and she didn't make a response, and half of them were when she had her chin, you saw her make this, what you've called a startled reaction up.
Yes, sir.
Would that be a fair estimate?
That would be fair, yes.
And the times that you saw her with her chin down and eyes closed, it was again just a brief glance. You weren't dialed in, focusing on her. Agreed?
Yes.
You agree with that?
I do agree.
Nothing else?
Mr. Anderson?
So the 4 or 5 times, is that when you saw the head jerk?
It was both. At times I would look over and she just chin down, eyes closed. And then I would look over again and I would see that and then see the head jerk.
And did you see that for what period of time approximately from when you first noticed that till the end? Was it half-hour period of time, 45 minutes, hour?
Approximately over an hour.
Were there, when you looked over, if you recall, was it one of those 2 states, or were there several times where you looked over and she did appear to be alert?
Those are the only times that I'd looked over.
So when you looked over during that period, it was either chin down or startling awake?
Yes.
Nothing else?
You said it was only during the playing of the video. Agreed?
Yes.
You understand that the video was less than an hour, correct?
Approximately an hour. Yes, sir.
It's about 50 minutes.
Yes, sir.
So based upon that, you couldn't have been observing this for over an hour. Agreed?
I object that we played it for 56 minutes.
The record's,
56 minutes.
it wasn't over an hour. Agreed?
Yes, sir.
And you can't tell the judge during those 56 minutes when you made the first observation. Agreed?
Agreed.
So you don't know if it was 15 minutes into the video, 30 minutes into the video. You can't say.
I cannot give an exact time. No, sir.
And all you do is, you said you saw it about this 4 or 5 times, correct?
Correct. Yes, sir.
And you're not in a position to say whether her head was down for any continuous period of time. Agreed?
Agree.
That's all, Judge.
Thank you, Detective.
Thanks, Judge.
Down. Is there anything else you want to say in support of your motion?
Judge, the video is obviously very important for the state's case. It was only played once. Clearly, we don't have enough time to play it again in closing, given the length of it. That would be our entire closing argument. Both sides are entitled to a fair trial with an attentive jury. So I think I ask that the court strike juror 4021 as one of the alternates.
Mr. Nelson?
I don't think they've established a factual basis that she was sleeping. I think that there's reason to believe, but I don't think that they've established a factual basis of that.
I tend to agree that there are some clues to suggest that the juror may have been nodding off, but there's certainly nothing conclusive, certainly nothing that would allow me to make such a significant finding. I'll say, for my part, I was scanning the juror from time to time during the playing of the video as well. And my eyes were not fixed on them the entire time, obviously, because I'm trying to pay attention to the video, but I also was watching the jurors. I did not notice anything that would suggest somebody was sleeping. I have a different perspective than others. I'm not saying mine's better, it's just different. I did notice a number of occasions where people were looking down because they were writing on their notes, or they were averting their eyes, but they weren't sleeping. So I just say that to point out that there can be other alternative explanations for certain observations. The other point, too, is that even if we did have a sleeping juror, and even if that juror slept the entire presentation of the jail interview, it is a recorded interview. And if that juror ends up being one of the 12, that juror has the ability to request to watch the video. So it's not like live testimony that is lost forever. This juror, if they make it to the deliberation room, has the ability to view the video again and take that into consideration as part of her deliberations. So for those reasons, the request is denied. Is there anything else?
No.
All right. Anything else from the defense?
Just like a break before we get into openings.
We will, yes. All right, let's take a short break. We will resume at 8:45.
Joint testing.
inside your eyes. Can you feel the rush?
Please be seated. All right, members of the jury, good morning. But I will read them aloud in case you prefer to listen. After that, Mr. Anderson will deliver the state's closing argument. We'll take about a 15-minute break, and then Mr. Trofasi will deliver Mr. Miu's closing argument, and then the state will have the opportunity for a brief rebuttal. After that, you'll begin your deliberations. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether Mr. Miu is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The state filed an information that alleges that Nicolae Miu committed crimes in St. Croix County, Wisconsin, on July 30, 2022. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against Mr. Miu in any way. It does not raise any inference of guilt. In count one of the information, Nicolae Miu is charged with first-degree intentional homicide, and you must consider whether he is guilty of that offense. If you are not satisfied that Mr. Miu is guilty of first-degree intentional homicide, you must consider whether or not he is guilty of second-degree intentional homicide, or first-degree reckless homicide, or second-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first and second-degree reckless homicide are different degrees of homicide. Homicide is the taking of a life of another human being. The degree of homicide defined by law depends on the facts and the circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements that are common to each crime. Both intentional and reckless homicide require that Mr. Miu caused the death of the victim. First and second degree intentional homicide required the state to prove the additional fact that Mr. Miu acted with intent to kill. First and second degree reckless homicide require that Mr. Miu acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of Mr. Miu's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Miu has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force that is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. The words great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. There is no duty to retreat. However, in determining whether Mr. Miu reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether Mr. Miu had the opportunity to retreat with safety, whether such retreat was feasible, and whether Mr. Miu knew of the opportunity to retreat. You should also consider whether Mr. Miu provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. However, if the attack that follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he reasonably believes he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. As applied to this case, the effect of the law of self-defense is Mr. Miu is not guilty of any homicide offense if he reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of second-degree intentional homicide if he caused the death of Isaac Schuman with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Miu is guilty of first-degree intentional homicide if he caused the death of Isaac Schuman with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of first-degree reckless homicide if he caused the death of Isaac Schuman by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. Mr. Miu is guilty of second-degree reckless homicide if he caused the death of Isaac Schuman by criminally reckless conduct. You will be asked to consider the privilege of self-defense in deciding whether the elements of first and second-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding of whether Mr. Miu acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second-degree intentional homicide or for first or second-degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find Mr. Miu not guilty. The facts necessary to constitute each crime will now be defined to you in greater detail. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find Mr. Miu guilty of first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following elements were present. First, Mr. Miu caused the death of Isaac Schuman. The word cause means that Mr. Miu's act was a substantial factor in producing the death. Second, Mr. Miu acted with the intent to kill Isaac Schuman. Third, Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The words intent to kill means that Mr. Miu had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that Mr. Miu acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act. It must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove Mr. Miu's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of first-degree intentional homicide requires that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either, one, that Mr. Miu did not actually believe he was in imminent danger of death or great bodily harm, or two, that Mr. Miu did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of Mr. Miu's belief is not an issue. You are not to be concerned I'll start over. You are to be concerned only with what Mr. Miu actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Miu is guilty of second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Miu caused Isaac Schuman's death with the intent to kill, and that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of first-degree intentional homicide, and you must consider whether he is guilty of second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether Mr. Miu is guilty of second-degree intentional homicide. Before you may find Mr. Miu guilty of second-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu caused the death of Isaac Schuman. Second, Mr. Miu acted with the intent to kill Isaac Schuman. Third, Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in the circumstances of Mr. Miu would not have believed that he was preventing or terminating an unlawful interference with his person. Or 2, that a reasonable person in the circumstances of Mr. Miu would not have believed he was in danger of imminent death or great bodily harm. Or 3, that a reasonable person in the circumstances of Mr. Miu would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed. In Mr. Miu's position, under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Miu's beliefs must be determined from his standpoint at the time of the acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schuman with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of second-degree intentional homicide. If you are not so satisfied, you must not find Mr. Miu guilty of second-degree intentional homicide, and you should consider whether he is guilty of first-degree reckless homicide, which is also a lesser-included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if, after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether Mr. Miu is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in Section 940.02, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Miu guilty of first-degree reckless homicide, the state must prove, by evidence that satisfies you beyond a reasonable doubt, that the following three elements were present. First, Mr. Miu caused the death of Isaac Schuman. The word cause means that Mr. Miu's act was a substantial factor in producing the death. Second, Mr. Miu caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Miu was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether Mr. Miu's conduct created an unreasonable risk to another. If Mr. Miu was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in this case that the risk was unreasonable. The third element, the circumstances of Mr. Miu's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Miu was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Miu's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of Mr. Miu's conduct showed utter disregard for human life. Consider also Mr. Miu's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schuman by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree reckless homicide. If you are not so satisfied, you must not find him guilty of first-degree reckless homicide, and you should consider whether he is guilty of second-degree reckless homicide, which is a lesser included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether Mr. Miu is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in Section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide is that first-degree offense requires proof of one additional element, that the circumstances of Mr. Miu's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Miu guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schuman by criminally reckless conduct, you should find him guilty of second-degree reckless homicide. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Miu guilty of more than one of those foregoing offenses. Mr. Miu is charged with attempted first-degree intentional homicide of Alexander Martin in count 2, Dante Carlson in count 3, Anthony Carlson in count 4, and Rhyley Mattison in count 5. For each count, you must first consider whether Mr. Miu is guilty of attempted first-degree intentional homicide. If you are not satisfied that Mr. Miu is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree recklessly endangering safety or second-degree recklessly endangering safety, which are less serious degrees of attempted criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide and first and second-degree recklessly endangering safety are different degrees of attempted homicide. The degree of attempted homicide defined by the law depends on the facts and the circumstances of each particular case. While the law separates attempted intentional homicides into 2 degrees, there are certain elements which are common to each crime. Both attempted first and second-degree intentional homicide require that Mr. Miu intended to kill another person and Mr. Miu did acts toward the commission of that crime which indicate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of the intended victim except for the intervention of another person or some extraneous factor. First and second-degree recklessly endangering safety requires proof that Mr. Miu recklessly endangered the safety of another human. First-degree recklessly endangering safety requires proof of one additional element: that the circumstances of Mr. Miu's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Miu has committed. For count 1, you were instructed on the law of self-defense. The same self-defense standards apply to your consideration of the charges of attempted intentional homicide that are alleged in counts 2 through 5. If you find that the elements of the crime have been proved in this case, the effect of the law of self-defense is as follows. Mr. Miu is not guilty of either attempted first or second-degree intentional homicide or first or second-degree recklessly endangering safety if he, 1, reasonably believed that he was preventing or terminating an unlawful interference with his person, and 2, reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Miu is guilty of attempted first-degree intentional homicide if he did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of first-degree recklessly endangering safety if he recklessly endangered the safety of another human under circumstances that showed utter disregard for human life. Mr. Miu is guilty of second-degree recklessly endangering safety if he recklessly endangered the safety of another human. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether Mr. Miu acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilt for attempted first or second-degree intentional homicide or first or second-degree recklessly endangering safety. If the state does not satisfy you that those facts are established by evidence, you will be instructed to find Mr. Miu not guilty. The elements of each crime will now be defined to you in greater detail. Before you may find Mr. Miu guilty of attempted first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu intended to kill the named person. For count 2, the state must prove Mr. Miu intended to kill Alexander Martin. For count 3, the state must prove that Mr. Miu intended to kill Dante Carlson. For count 4, the state must prove that Mr. Miu intended to kill Anthony Carlson. For count 5, the state must prove that Mr. Miu intended to kill Rhyley Mattison. Intent to kill means that Mr. Miu had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. The second element, Mr. Miu did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person except for the intervention of another person or some other extraneous factor. Unequivocally means that no other interference or, Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from Mr. Miu's acts under the circumstances. Another person means anyone but Mr. Miu and may include the intended victim. An extraneous factor is something outside Mr. Miu's knowledge or control. The third element, Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. While the law requires that Mr. Miu acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing guilt of a defendant, the state is not required to prove Mr. Miu's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of attempted first-degree intentional homicide requires that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, 1, Mr. Miu did not actually believe he was in imminent danger of death or great bodily harm, or 2, that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or, 2, that Mr. Miu did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of Mr. Miu's belief is not an issue. You are to be concerned only with what Mr. Miu actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Miu is guilty of attempted second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Miu intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson for count 3, Anthony Carlson for count 4, and Rhyley Mattison for count 5, and that Mr. Miu's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some other extraneous factor, and that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of attempted first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted first-degree intentional homicide, and you must consider whether Mr. Miu is guilty of attempted second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether Mr. Miu is guilty of attempted second-degree intentional homicide. Before you may find Mr. Miu guilty of attempted second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu intended to kill the named person. Second, Mr. Miu did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person, except for the intervention of another person or some extraneous factor. Third, Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally, another person, and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that Mr. Miu not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in Mr. Miu's circumstances would not have believed that he was preventing or terminating an unlawful interference with his person, or 2, that a reasonable person in Mr. Miu's circumstances would not have believed he was in danger of imminent death or great bodily harm, or 3, that a reasonable person in Mr. Miu's circumstances would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Mr. Miu's position under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Miu's beliefs must be determined from the standpoint of Mr. Miu at the time of his acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Miu intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, Rhyley Mattison for count 5, and that Mr. Miu's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some extraneous factor, and that Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of attempted second-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted second-degree intentional homicide, and you must consider whether Mr. Miu is guilty of first-degree recklessly endangering safety, as defined in Section 941.30 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted second-degree intentional homicide before considering the offense of first-degree recklessly endangering safety. However, if after full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of attempted second-degree intentional homicide, you should consider whether Mr. Miu is guilty of first-degree recklessly endangering safety. First-degree recklessly endangering safety, as defined in Section 941.30, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Miu guilty of first-degree recklessly endangering safety, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu endangered the safety of another human being. Second, Mr. Miu endangered the safety of another by Mr. Miu endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Miu was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should also consider the evidence relating to self-defense in deciding whether Mr. Miu's conduct created an unreasonable risk to another. If Mr. Miu was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. The third element, the circumstances of Mr. Miu's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Miu was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should also consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Miu's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of Mr. Miu's conduct showed utter disregard for human life. Consider also Mr. Miu's conduct after the act alleged to have endangered safety to the extent that it helps you to decide whether or not the circumstances showed utter disregard for human life at the time the act allegedly to have endangered safety occurred. If you are satisfied beyond a reasonable doubt that Mr. Miu recklessly endangered the safety of another, those named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, and Rhyley Mattison count 5, and the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree recklessly endangering safety. If you are not so satisfied, you must not find him guilty of first-degree recklessly endangering safety, and you should consider whether he is guilty of second-degree recklessly endangering safety, which is a lesser included offense of first-degree recklessly endangering safety. You should make every reasonable effort to agree unanimously on the charge of first-degree recklessly endangering safety before considering the offense of second-degree recklessly endangering safety. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree recklessly endangering safety, you should consider whether Mr. Miu is guilty of second-degree recklessly endangering safety. Second-degree recklessly endangering safety, as defined in Section 941.30, Parent 2 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The differences between first and second-degree recklessly endangering safety is that the first-degree offense requires proof of one additional element: that the circumstances of Mr. Miu's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree recklessly endangering safety were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Miu guilty of second-degree recklessly endangering safety. In other words, if you are satisfied beyond a reasonable doubt that Mr. Miu endangered the safety of Alexander Martin, Dante Carlson, Anthony Carlson, or Rhyley Mattison by criminally reckless conduct, you should find him guilty of second-degree recklessly endangering safety. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Miu guilty of more than one of the foregoing offenses for each count.
Sorry, Judge, could we take a brief break, please?
Yes, please take the jury out.
All rise for the jury.
Let's return in 5. No. I think I speak for everyone in the courtroom. That was a well-timed break. All right, is everyone ready to listen to the judge talk some more? All right. I'm picking up on page 20. All right. In count 6 of the information, the judge alleged that Mr. Miu committed battery. Battery, as defined in section 940.19, parent 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with the intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find Mr. Miu guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following 4 elements were present.
Judge, can we approach quick?
Yes? lawyer loves to tell the judge he made a mistake. I made a mistake. In count 6 of the information, the state alleged that Mr. Miu committed battery. So let me get to the elements. First, Mr. Miu caused bodily harm to Mattison Cohen. The word cause means that Mr. Miu's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Second element, Mr. Miu intended to cause bodily harm to Ms. Cohen. Intent to cause bodily harm means that Mr. Miu had the mental purpose to cause bodily harm to another human being, or was aware that his conduct was practically certain to cause bodily harm to another human being. The third element, Mr. Miu caused bodily harm without the consent of Ms. Cohen. The fourth element, Mr. Miu knew that Ms. Cohen did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent and knowledge. The state must prove by evidence that satisfies you beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. You were instructed on the law of self-defense in count 1. The same self-defense standards apply to your consideration of the charge of battery alleged in count 6. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved and that Mr. Miu did not act lawfully in self-defense, you should find him guilty. If you are not so satisfied, you must find him not guilty. The information alleges not only that Mr. Miu committed the crimes charged in counts 1 through 6, but also that he did so while using a dangerous weapon. If you find Mr. Miu guilty on any of these counts, you must answer the following question. Did Mr. Miu commit the crime while using a dangerous weapon? Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Again, great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that Mr. Miu committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that Mr. Miu is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that Mr. Miu is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with Mr. Miu's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give Mr. Miu the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Mr. Miu the benefit of any reasonable doubt that remains after carefully considering all the evidence in this case. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts, according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that Mr. Miu committed the offense before you may find him guilty. Evidence has been presented relating to Mr. Miu's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Remarks of the attorneys are not evidence. If their remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to the greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observation. Start over. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability, of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's age, race, national origin, religion, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. We've now reached the stage where the attorneys will deliver their closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. First, we'll hear from Mr. Anderson. When he's done, we'll take a short break. After that, we'll hear from Mr. Sharafi, and then Mr. Anderson will be permitted to give a short rebuttal. Mr. Anderson.
Thank you, Judge. Absolutely senseless and horrific acts of violence. And all Nicolae Miu had to do was walk away. All he had to do was walk away. That's what you've seen in this case. You saw he told Lieutenant Hart, "They told me I can't run away." Obviously not true. Think about the result of his actions. Everything you've seen in this trial, the horrific injuries, the death of Isaac. Why didn't he just walk away? His only explanation when testifying was, "I stood my ground. I stood my ground." First of all, Wisconsin is not a stand your ground state.
Objection. Overruled.
I'll talk about that specifically from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the boys who testified. It was cruel what they were calling Nicolae. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nicolae did. You heard from Alina, Isaac's mother, about her son Isaac. He was 17 years old when he was killed. He enjoyed golfing, spending time with friends. He recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nicolae would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds, from the point he punches Mattison until you see him walking off after stabbing 5 people. He's not seen, Nicolae is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly it wasn't for his eyewitness testimony, but he took a video. He took a video that captured a different angle than Juwan's video. It's grainy, it's difficult to see, but you can see enough. And it shows Nicolae seeking Dante out and stabbing him when his group is in the opposite direction. Nicolae walks into a crowd of people, stabs Dante. Before I show you that video again, I need to provide some context from Juwan's video.
Take it off.
We have the screen, please. So here at 2 minutes and 6 seconds, this is after Nicolae has stabbed the 4 people that you do see parts of on the video. He's standing next to Ariel. Ariel's there. Nicolae's not by himself. Two minutes, 8 seconds, that's the last you'll see of Nicolae until you see him walking off in this video. You see Dante, or AJ, the boys running back to their tubes, and you see Larian filming in the background. Larian captured what Nicolae was doing at this point, even though this video didn't. And here, in a moment, you can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larian's video, Dante's just been stabbed. Next, you see of Nicolae, he's walking off. You can see Dante in the background, holding his stomach, looking down at his wound. Well, actually, you can keep it up for a second, sorry. And then for further context, you see Alex Vang running to Isaac. Let's see Larian's video. Okay, I have the screen. Remember, Nicolae admitted he walked up to he walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nicolae, dark swim trunks, bigger build. On the right, you can see Dante, swim trunks, lighter on top, darker on bottom. You'll see Nicolae walk up to Dante and stab him in the chest. You'll see Dante recoil from the stab. You see the boys on the right running to their tubes. And in the second here, you'll see Alex Vang. You'll zoom in on him as he runs to Isaac. I'm going to show that again. So, a few things to note. There's nothing between Nicolae and Larian. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nicolae, except his group in the distance that you can't see on video. He walks away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense. And recall too the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. It makes sense from how the analyst described DNA and how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off looking great after they testify. There's some exceptions, obviously the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nicolae's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what was going on the whole time. She was completely sober. You heard her testify, Nicolae punched Mattison. She has zero connection with the group anymore, zero contact. Her and Quentin broke up. Tony is another one. He only comes in to break up what he thinks is a fist fight. He's directing Nicolae towards Nicolae's group. Nicolae turns and stabs him twice. Another one I submit to you is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nicolae to leave. In the middle, when Nicolae turns back to Isaac, Isaac puts his hands up, fingers splayed. The only other thing you see of Isaac is him standing in the background. When the other boys are mocking, calling names to Nicolae, Isaac is just standing in the background. He's not saying anything. He's not doing anything. He's not jeering. He's just standing there holding their tubes. There's been a pretty serious mischaracterization of Isaac's actions with regard to when he gets stabbed. Defense has tried to classify it as a strangulation. Defense accused the state in openings of being selective in the photos we used, the frames, to try to show a certain narrative about Nicolae smiling. As you've seen, he's smiling a lot in the video. But defense is actually doing that when it comes to Isaac. Nicolae never said anything about being choked, never said anything about pain on his neck, even when specifically asked by the start nurse, never mentions anything. And the video doesn't lie. So on the left, Nicolae has just stabbed Rhyley, who you heard from multiple witnesses were just standing there. Tony comes to try to break it up. Nicolae stabs him twice. Isaac, just off frame, I submit to you, he just saw Nicolae stab those two people completely unprovoked. Although he was in the background the whole time, not doing anything, he came to their aid. And he pushes Nicolae. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nicolae's own action of thrusting the knife into Isaac's heart that moves Isaac's hands. You can even see from the release, it's a push. He's not sitting there left holding his hands out in a choking motion. Can we take the screen down?
Yes.
I'm going to show you the video so you can see it's obviously a push. While my computer is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nicolae stab two people who posed no threat to Nicolae. Tony was breaking up the fight. He had actually ignored Nicolae at first, walked past him, pushed Dante out of the way. Rhyley was just standing there. I'm at 2 minutes and 3 seconds. Can we have the screen? Clearly a push. Defense has mischaracterized the entire situation as 13 on 1, implying it's some sort of mob beating up Nicolae. It's not even 13 people yelling at Nicolae. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the background, not yelling anything. It's 13 people in the proximity, only 2 close to him, 2 tiny females. Nicolae's clearly not afraid of the boys. He ran up on the boys, turns his back on them and others multiple times. Even at worst, this is a 2-on-1 with AJ and Dante. But even then, as you saw in the video, Ariel's right there. It's more like a 2-on-2. Ariel's right there. Plus, Tony comes in as a neutral party to separate things. It's not 13 on 1. As soon as AJ gets disemboweled, you see people start to move away. So there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife. So why try to mischaracterize the situation? Because there's some things that are hard to explain otherwise for defense. Turn on the screen, please. This is the second time you saw in the video that Nicolae turns his back on the boys and people from the Carlson group. You don't turn your back on somebody. It's common sense. You don't check your common sense at the door when you serve as a jury. You don't turn your back on somebody if you're afraid of them, especially if you're so afraid you got to reach for your knife. You can't be that afraid that he's got to reach for his knife and so unafraid that he turns his back on them. He was angry, not afraid. That image on the right is only less than 30 seconds after he turns his back on them, touching his knife. The defense tried to explain that change from in that 30-second window by saying he was getting pushed by Mattison and Rhyley. He was getting pushed. They're lightly touching his arms and they're tiny. They're not in his face. You can see in the images, they're standing close. They're not in his face. They're not shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing, yelling at him to leave. I'm going to back up a little bit and talk about Nicolae looking for the phone. So Eric Von Williams from Nicolae's group, you heard testify, before any of this happened, he was concerned about Nicolae's behavior. He was concerned that people were going to think he was a predator. Ernesto told Nicolae not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nicolae went. Sandy said he went twice, was back for 5 to 10 minutes, then went again over by the boys. Defense argued in opening that the boys' goal, their goal was to humiliate Nicolae. Clearly, he wasn't looking for little girls. But the boys are not completely unreasonable in their belief. Eric Von Williams thought the same thing. They reacted wrong, but they just didn't invent this whole thing in order to humiliate Nicolae. What about Nicolae? 52 years old, apparently sober, according to, I think, what defense will argue. He didn't have any signs of intoxication when law enforcement made contact with him, but he certainly made a point of telling Lieutenant Hart multiple times how much he was boozing and drinking on the river. He can't let it go that he was insulted. So much so that as the boys are tubing away from him, all Nicolae has to do is stand there. He doesn't even have to take a step back. He just has to stand there, let the boys continue tubing. They're down in their tubes. He starts walking up to them, touches his knife, and then runs up to them. You heard Nicolae's ridiculous description or explanation for why he ran up on the boys. Because one was holding a phone, he thought it was Ariel's phone. You also heard Nicolae had to concede, had to admit that pretty much everyone on the river had those phone cases. Another double standard from defense is physical attributes of those involved. They wanted to elicit evidence that Nicolae is feeble. Sandy, he wasn't feeble according to Sandy. He had a surgery a couple years ago, recovered in a few weeks. Maybe things took him a little longer than they did before. He wasn't feeble according to Ernesto. You heard Ernesto, when he was being asked about the stabbing, said, he's a big guy, he was in the army, he doesn't need a knife to defend himself. He didn't say, oh, he's this fragile old guy. He's clearly not feeble, as you see in the video. He runs up on these boys in the water. He leaves behind devastating, devastating injuries. Slices clean through 2 of Isaac's ribs. He comes out of the whole event essentially uninjured. While defense tries to argue that Nicolae is this feeble old man, they ignore that the only 2 people actually standing close to Nicolae are these 2 females that are barely over 100 pounds. If the boys are a threat, why does Nicolae run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent. You saw how awkward it was for Nicolae to try to explain this transition from 0 fear to 10 out of 10 fear. He's got to take out his knife. Try to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nicolae, the demonic look on his face, staring through people, smirking. Defense argued in opening, it's a slide tour here, there. You know, after seeing the video so many times, that's not the case. When he's not glaring, he's smirking in the video. Recall, I asked Ernesto, his best friend, when he was trying to describe the shock of Nicolae, I asked, was he smiling? He didn't say, yeah, he smiles when he's scared. He smiles when he's nervous. He said, who's going to smile in a situation where they're in shock or in fear? Nicolae was angry. He wasn't afraid. He's smirking even as he's holding the knife. Why didn't he just walk away? Defense had tried to argue there's rocks unstable, his sandals were bad, didn't stop him from running up to the boys as they're tubing away from him. Why didn't he just hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else was moving forward and responded to Nicolae punching Mattison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nicolae just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if he would have looked down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nicolae did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm. So let's talk. Here's Owen reacting, as you see. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife. So let's talk about the punch to Mattison. I submit to you the evidence shows clearly, beyond a reasonable doubt, Nicolae punched her. She fell backwards, but caught herself. Multiple witnesses testified to seeing her falling backwards. Defense is saying, arguing on cross, well, she's not wet, she didn't actually fall down. If witnesses are all standing in that kind of semicircle around Nicolae, she gets punched and falls backwards, and then their attention's back to Nicolae as Dante's hitting him. They're not going to see that she caught herself. They're going to think she fell down. Look at her position next to Rhyley. They're shoulder to shoulder in front of Nicolae before the camera pans away. When the camera pans back, now Dante's shoulder to shoulder with Rhyley, and Maddie is back. She clearly got knocked backwards. Her sunglasses aren't on her head anymore. Defense has a double standard about that too. If there's not a photo of it, it didn't happen. If there's not a photo of an injury, it didn't happen. We know Nicolae got punched. He didn't have any injury. Defense can't have it both ways. So I'll turn and talk a little bit about memory, credibility. Obviously, a witness's memory is better closer to the event. That's obvious. Alcohol is going to affect memory. Traumatic events can affect memory. How fast it happens is going to affect memory. But crucially, and absolutely crucially, there's a huge difference between getting some details wrong, right hand, left hand, sequence of events, and making up an entire story like Nicolae did. Defense has tried to highlight throughout the trial, Nicolae was in this traumatic experience, give him a break. It's understandable, he made up all these lies, told this whole story. Even though he looks calm and collected in the videos, he's convincing in the videos, talking to the sheriff, talking to Lieutenant Hart. But don't give any sort of credence to the theory that trauma affects memory for anyone in the Carlson's group, any of the boys, any who were stabbed, any who had to drag Isaac as he's bleeding to death to the shore. AJ, who was disemboweled, don't give any credence that trauma might affect their memory and how accurately they can remember all the details. But Nicolae, who invented an entire story, tried to skip through the crowd. Give him credence for that. You saw what happened to all these witnesses, how fast it happened. It's not surprising, some of the details are wrong. But the major point is accurate, is consistent. This all started when Nicolae punched Mattison, whether it was the right hand or left hand. You heard the turmoil of the boys when they realized Isaac is stabbed. Clearly a traumatic experience. There's a big difference between details and invention. Think about the most basic example. You and say your partner go to the grocery store. Park your car, you're leaving the grocery store. You think your car's parked over there, they think it's parked over here. You still know the car's parked in the parking lot, even if you can't remember where it's parked. The same is true for the punch to Mattison. You heard from 10 people, both from the Carlson group and the Boyd's group, that Nicolae struck Mattison. So let's talk a little bit about witnesses from Nicolae's group. Ariel, what did he say? At trial, he says Nick defended himself. Can't really say how. Never said that when interviewed with law enforcement. He denied even being close to Nicolae. Remember, Ariel was there when he stabbed Dante. He was right there when Nicolae stabbed Rhyley, Tony, and Isaac. Law enforcement went there with the frame of Ariel standing next to Nicolae when Nicolae has the bloody knife. Ariel denies seeing anything to law enforcement of what Nicolae did. Ernesto, at trial, testified he didn't see Nicolae get hit, just saw him down in the water. Said he couldn't remember Nicolae saying, "They took my knife." You saw on the body cam, he said that repeatedly. He testified that somebody was walking towards him, he pointed at him, "Get back." Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, Nicolae, get out, Nicolae walking out, and then he said, and that's it. Never said anything about anyone pointing at him and walking towards him. When I asked, he said, I wasn't asked that question. But he described that event. He also wasn't asked more than 10 times if Nicolae said they took my knife. So, about the punch to Mattison again. Sergio, he's in Nicolae's group. He had walked out a little ways. You can see him in the photo on the left in the top right. He had the white shirt, white bucket hat. He testified he saw the blonde girl in the black leotard walk over to Nicolae and say, go, go, go. He said it repeatedly to law enforcement. And he said Nicolae pushed her. So this is what it would have looked like from his perspective, although a lot farther back in that photo on the right. How could he have seen Nicolae do anything to Mattison unless she got pushed back, punched back, something violent, not some light push? He's not going to see that from where he was. Mattison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nicolae just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police at the scene she was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek, her heartbeat in her cheek. Maddie testified she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, don't worry about it. This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat. But in determining whether Nicolae's actions, whether his use of force was reasonable to prevent or terminate the interference, you may consider whether he had the opportunity to retreat with safety, whether such retreat was feasible, and whether he knew of the opportunity. He turned his back on them multiple times facing open water. People were yelling at him to leave, to walk away, to go. And he didn't. Instead, he took out his knife. That is not reasonable. You heard from Sheena Lowell, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson, and AJ about the strike to Mattison. You heard from the boys, Ryan Nelson, Juwan Cockfield, Landon Wire, and Alex Vang. Alex Vang originally described it as slap. You heard from Owen that he heard an impact and saw Mattison fall back and catch herself. Defense has to argue that they're all either lying or mistaken. All these witnesses, including Sergio. If they're lying, why would Quentin say I saw some swelling and some slight redness, but didn't see the punch? Why wouldn't he just say, yeah, I saw the punch too? Why wouldn't Tony say he saw the punch? Why wouldn't Tony say he saw Rhyley get stabbed and she's just standing there? They tried to explain what happened as best they could remember. The punch isn't on video, but you see the reaction. You hear Dante yell, you can't hit a woman before Rhyley is stabbed. They obviously didn't plan this lie in the chaos of the moment. So the only thing defense can argue is they're mistaken. That all of these people standing around Nicolae in that half circle proximate shape, they're all looking in that direction, including Sergio, including Sheena, who was by the group, the tubes for the crossing group. They all were wrong in what they saw. Another defense double standard, it's relatively minor, but I submit to you it shows that they're grasping at straws, is this trying to put Nicolae's group in a different category. There's the drunks on the Apple River, then there's Nicolae's group. About half you raised your hand that you've been on the Apple River. That's what people do on the Apple River. They go out, they tube, and they drink. Nicolae was in the exact same boat they were in. He wasn't bird watching and this group of drunk teenagers ran up on him. He knew what it's about. He'd been on the river before. Another thing about the punch to Mattison, you heard that they didn't get to see the video before giving their statements. Even Jawan, who took the video, said he got far enough to get the screenshot of Nicolae, and then law enforcement took his phone. He didn't get to see the video. You saw what happens in this case if somebody lies about something that happened on video, because Nicolae got burned by that. He made up complete and total lies. Video showed he wasn't telling the truth. The video happens to not show the punch, but it still corroborates what all those witnesses said. So, count 6 is battery to Mattison Coleman. It has 4 elements. Nicolae caused the battery to Maddie, caused the injury, the harm, the pain. She testified to that. He intended to cause the harm, despite his denial. I submit to you that's clear. You don't punch somebody without intending to cause harm. She didn't consent. She testified to that. He knew she didn't consent. She's a stranger. Obviously, she didn't consent. He knew that. Punching Mattison was not self-defense. Again, there's no duty to retreat, but you have to consider the opportunity to retreat, knowledge of the opportunity to retreat, and whether the use of force was necessary in preventing the unlawful or the interference in Nicolae's person. So what is the interference at the time he punches Mattison? The boys are saying cruel things to him. Maddie and Rhyley are standing in front of him, lightly touching his shoulders. People are pointing and laughing, the boys. Maddie and Rhyley aren't in his face. They're standing close, but they're not in his face. What amount of force was necessary to prevent that interference? People yelling at him, Maddie and Rhyley standing close. What amount of force was necessary? Absolutely zero. Just walk away. That's what people are yelling at him to do, just walk away. Instead, he takes out his knife and punches Mattison. Regardless of whether you were convinced beyond a reasonable doubt it was a punch, Nicolae essentially admitted to pushing her. Sergio said it was a push, although when asked, he couldn't remember if it was a push or a punch. There's still provocation. Your jury instructions talk about provocation. And how that affects self-defense. A person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape or otherwise avoid death or grave bodily harm. Remember, Nicolae ran up on these boys who were tubing away. They didn't run up on him. He ran up on them as they're tubing away from him because they insulted him. He was angry. He didn't walk away from the boys to leave the situation. He went over to Maddie, who was yelling at him to leave, and he lies to her and says, "They took my snorkel." I'm going to play that for you so you can hear it. All right, this is at 105 in the video. I'm ready.
Go! Kids, go! 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 Kids, go! 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 Kids, go! Go! Doesn't matter.
You can take it down. He didn't go over there to extricate himself from the situation. He went over there and accused the boys of taking a snorkel, which was a lie. And he had just ran up on the boys. So after he runs up on the boys as they're tubing away, he goes and tells Maddie they took my snorkel. He's standing there smirking at people, takes out his knife, either punches or pushes Maddie. That's provocation. Defense has zero reasonable argument, especially when it comes to Tony, Rhyley, Isaac, and Dante. Nicolae gets punched. He gets struck with an open hand twice. He gets ineffectually pushed by AJ. It doesn't do anything. Nicolae pops right up and disembowels AJ. After Nicolae goes down in the water, nobody approaches him. Nobody. Nobody goes to kick him. Nobody goes to punch him. Nobody goes to push him again. Tony, with Nicolae down on the ground, Tony walks by Nicolae with his back to Nicolae, yelling, "Get back to Dante." He turns around to tell Nicolae to get away, and Nicolae turns around and stabs him. Nicolae was facing his group with an open path of escape after provoking a reaction. He just stabbed Rhyley before stabbing Tony. After stabbing those two, he stabs Isaac. After that, after Ariel's there, he walks over to Dante, stabs Dante in the chest, right below his ribs, right below his heart. So self-defense. I submit to you the state has proven beyond a reasonable doubt this was not justified self-defense, and Nicolae knew it. He knew it from the moment he did it. First of all, imminent threat of death or great bodily harm. He's not in an alley with no way out, with people blocking his exit. He's on an open river, 150 feet wide, people yelling at him to get away. None of them are armed. Punch, 2 open hand strikes, ineffectual push. Look at the definition of great bodily harm, whether he reasonably believed death or great bodily harm is imminent. For attempted first-degree homicide for Dante, AJ, Tony, and Rhyley, the state has to prove that he intended to kill each of them. And the acts demonstrate unequivocally, under all circumstances, that he had formed the intent and would have caused the death of each of them, except for the intervention of some other person and an extraneous factor. Third, the defendant not actually believed that the force used was necessary to prevent death, imminent death, or great bodily harm. So for the intent to kill, but for outside circumstances. AJ, it's beyond clear. He would have died but for the blood in the helicopter. He would have died but not for the surgery Dr. Meyer performed. He is lucky, extremely lucky to be alive. What else was Nicolae's intent but to kill when he slices him up like that? He had the knife blade up. That wasn't an accident. He did not know. The first thing he does with it is slice up AJ's stomach. Rhyley, he slashes across the ribs. You saw the horrific nature of those wounds. He cut into her stomach, cut into her diaphragm. Luckily, he didn't hit any major arteries or her heart or lung. Tony blocked one stab, so Nicolae stabbed him again. When he blocked, you saw the injury. It was very close to where AJ's artery was severed. Dante was stabbed again, just below his heart. But for Nicolae missing vital organs, but for medical intervention. Miu claimed he had tunnel vision. Oh, sorry, back up. So Dr. Meyer also testified, you heard about anytime there's a puncture wound to the torso, the stomach, they have to go in because there's so many major veins, arteries, organs, they have to go in to make sure something major isn't done. Nicolae killed Isaac, almost killed AJ. Rhyley needed emergency surgery. Luckily, but for dumb luck, missed the vital organs of Dante, but for AJ blocking one strike, missing vital organs, he survived. Nicolae said he had tunnel vision. I thought everyone close to me was attacking me. I thought anyone touched me was attacking me. He didn't stab Ariel, and Ariel came up. Makes the tunnel vision claim a little bit unconvincing. For first-degree intentional homicide of Isaac Schuman, Nicolae stabbed him so hard, he cut clean through 2 ribs. The wound was deeper than it was wide. He sliced Isaac's heart. There's no other intent when you stab somebody directly in the heart than to kill. An intent to kill doesn't need to be planned ahead of time. Your jury instructions talk about that. It doesn't have to be formed a week, a month, a day, even a minute in advance. As long as he had that intent when he does the act, that's intentional homicide. The first element is he caused Isaac's death. That's obvious. Acted with intent to kill. I've addressed that. Did not actually believe the force was necessary to prevent imminent death or great bodily harm. I'm going to get to that in a little bit for all the counts. Third element, he did not reasonably believe the force was necessary. That also goes to, I'm sorry, that's part of the third element. So how do we know, how can what Nicolae believe? What a reasonable person would believe. That there's only one person on the planet who experienced what Nicolae experienced, saw what he saw, was standing in his place. And what did Nicolae believe? He believed it was unjustified. The very first thing he does is walk away. Doesn't run. Doesn't tell Ariel or Ernesto anything. Doesn't tell them to run. He walks away from his group to the other side of the river. At some point rinses the knife because it wasn't covered in blood. Throws the knife onto the bank before walking back to his group. Says nothing to his group other than they took my knife. Puts on his hat, sunglasses, and shirt, and sits down in his team. He's the one, as he said in his interview, who says, let's go, let's get out of here. They can't right away because Eric isn't there. You saw, and as they're tubing down the river, you saw the video of him casually paddling along. You saw, so plan 1, get away. Slink away with the crowd. That didn't work. Plan 2, play dumb. Can you take the screen down, please?
Camera recording started.
Still doing all right?
Yeah.
Okay.
What's going
Temperature's okay in here?
Yeah.
Okay.
Somebody,
All right.
I hear somebody got stabbed, and I fit the description.
Yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay. All right.
So I don't know. Okay, well,
Did you see anybody injured?
no.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
You know, yeah, calling each other names, but, you know, that's, I've seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know,
Okay.
kids being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Sure, they're drunk, kids being kids. That's what he told Sheriff Knudsen, and he's acting like he has no idea what's going on. Clearly not in shock. You need to get down, sorry. Clearly not in shock. Clearly Nicolae knows that was not justified, and he's looking out for Nicolae. Slinking away didn't work. Plain dumb didn't work. He's told he's under arrest for homicide. Plan 3. Completely lie about what happened as to justify him using lethal force. The boys pulled out the knives. They twisted their arm, poked him. That's what he used, poke, with their own knife. So first degree intentional homicide and second degree intentional homicide are very similar. For first degree, did Nicolae actually believe? Did he actually believe that he was not justified? For second degree, it's the reasonable person standard. I submit to you, it doesn't make a difference in this case. It's crystal clear. He knew he wasn't justified. He knew he wasn't justified. It's crystal clear from his actions after the fact. Can't be explained away by shock. He's clearly not in shock. The use of force on AJ, stabbing Rhyley just standing there, stabbing Tony trying to break it up, stabbing Isaac directly in the heart. Ariel's there, walking up to Dante and stabbing him. The injuries he left behind, that all shows his intent. Again, you have to consider whether he knew he could retreat, whether there was a safe escape. He could have just walked away. He could have just raised his knife. He didn't do any of that. He just stood there with the knife until he punched Mattison. He touched his knife when before running up on the boys. He takes out the knife, opens the blade up, never says anything, never walks away, never takes a step back, never raises the knife, never yells for help. He's smirking with the knife in his hand. Finally, after stabbing 5 people, then he walks away. Doesn't run, walks. It's shocking to see what Nicolae did in this case, to see the injuries, and then see his calm, cool demeanor after the fact, tubing down the river, sitting in his tube at the scene of the chaos, casually talking to Sheriff Knudsen, making up this huge lie to Lieutenant Hart. He even lied to the start nurse at 9 p.m., so 5 hours after the incident, about the boy pulling a knife, twisting his arm, poking him with his own knife. He even lied to Sandy after the arrest. Nick recognizes that what happened is not justified self-defense. Just standing there with the knife, not walking away when he clearly can. So even to Sandy, after he's charged, he casts blame on her and the group for not hearing him yelling. He never yelled. Normally, it'd be difficult to know what a defendant believed in a self-defense case, not in this case. Nicolae was not in fear, he snapped. He was angry, and he snapped, and he knew it. His actions show he knew he did not reasonably believe the amount of force was necessary. He was not actually in fear. If he was actually in fear, he would have left. How else? Do you know what other clues? Think about his testimony. We submit to you that this is first-degree intentional homicide and first-degree attempted homicide. His acts clearly show intent. But if you can't agree unanimously on that, as your jury instructions tell you, you have to consider second degree. Again, the difference in second degree is Nicolae's belief versus reasonable person. Here you know, I submit to you his belief from his own conduct. Afterwards, he knew it was not justified. If you can't agree on second degree, you consider first degree reckless homicide, first degree reckless endanger of safety. Element 1, Nicolae endangered the safety of another human being. That's obvious. Endangered the safety of another by criminally reckless conduct. The jury instructions define criminally reckless conduct, creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and just stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there to utter disregard? He just walks away. He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims. And he tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did he commit these crimes while possessing a dangerous weapon, the pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool, totally fine to carry it for self-defense, totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nicolae he was not justified in self-defense when he attacked these people. So we ask that you answer yes on that question. In the end, what is beyond clear, Nicolae knew this was not self-defense. All of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific. They were senseless. He killed Isaac Schuman, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Rhyley who's just standing there, and then walks up to Dante. That walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument that this was self-defense. He was angry. There's no rational reason Nicolae, his group's over here, would walk this way towards the group of people to stab Dante. Senseless and horrific acts. The state has to find Nicolae Miu guilty of all charges. Thank you.
Thank you. We will take a 10-minute recess. We'll be reconvening at 11:05. Please take the jury out.
All rise for the jury.
Two hearts inside your eyes. Can you feel the rush? Closing.
Please be seated. All right, we are back in the presence of the jury with the attorneys and Mr. Miu. Mr. Truffesy.
May it please the court, counsel. So, ladies and gentlemen, in his opening statement, Attorney Nelson said to you, one of the things you're gonna have to determine is what happened on July 30th, 2022. Well, what happened on July 30th, 2022 is a group of drunk teenagers led by the ringleader, Juwan Cockfield, saw an opportunity to torment a man who was by himself. They taunted him. They called him names like raper and pedophile and predator. They did this for no legitimate purpose. When they did this, they're yelling and carrying on. It attracted the attention of another group, right? Led by Madison Cohen and Dante Carlson. 6 drunk teenagers quickly turned into 13. 13 against 1. They got in his face. They screamed at him. They called him names. They swore at him. They put their hands on him. And the group of 6, they became brave. The group of 6 became brave to the point that they circle him and start taunting him. They do this to a man who has done nothing, absolutely nothing to them. Then, when that man, Mr. Miu, tries to create some space between him and Madison Cohen, they pounce. They punch him. They push him. They slap him. They hit him again. They choke him from all directions. And Nick Miu acts in self-defense. That's what happened on July 30th, 2022. I just want to give you guys a little bit of an indication as to kind of where I'm going to go, and more importantly, what I think you need to think about when you are back there thinking about the evidence, okay? First is the law. 1, there is no duty to retreat, period. That is the only requirement. In this state, bullies like Madison Cohen don't get to tell us where to go. Bullies like Madison Cohen don't get to get in our face and require that we leave. That's not a requirement here. Keep that in mind. 2, subjective beliefs, okay? When you're listening to or contemplating the evidence and replaying it in your mind, you are to do that and consider the beliefs, not the actions, but the beliefs of Mr. Miu. And when you do that, you are to do that from his perspective at the time that the events were occurring. So while we have a video, that video is from the perspective of Joanne Cockfield. The video perspective that the jury is required to consider it is as Nick Miu is holding the camera. I'm going to address this a little bit later, but the idea of provocation. Whether or not Nick intentionally caused harm to Madison Cohen. That is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here, okay? Because in this case, self-defense has been alleged. Remember when you're back there, Nick Miu doesn't have to prove he acted in self-defense. They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable. Okay? So the way that I look at this video, the main video of Juwan Cockfield, we've all seen the 9-second video where he's screaming at Mr. Miu, calling him a raper. I'm not talking about that. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part, all right? Before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think 2 things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Miu, right? I think to a person, they testified, yeah, we were really concerned about Mr. Miu. And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him? Or is this what drunk teenagers who are terrified, is that what they look like? Does that make sense to you? Because you heard this. As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again, all Nick Miu had to do was walk away. Well, you heard from each one of those tubers, those drunk teenagers, we could have passed. When he walked over by Madison Cohen, we could have passed. And you heard Owen Pelican. I didn't want to pass. I wanted to see how this was going to play out. Why? Because Juwan Cockfield was recording this entire incident. They wanted to see what was going to happen. They're not afraid. They want to see how this is going to play out. And Juwan Cockfield said it best of all. It's for the culture. He wanted to put it on the internet so other people could see. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to get away from them? If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them? Those are questions that you all can answer. Or an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the internet? Which one of those 2 things, based on the evidence that you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Miu's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls. But he also says, the boys didn't invent that. No, they pretty much invented that. And why do we, or how do we know that? So that's not on video anywhere, right? They don't mention it, they don't say anything about Nick Miu telling them that, right? Every one of them who speaks to the police provides a statement about what happened. Zero mention to the police that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk, and that would have interested him. Investigator didn't testify. Said he would have mentioned, if any of these kids would have mentioned little girls, I would have taken note of that. So, what's the alternative? Why did they say that? I would submit to you that what kind of person does what these kids did to him, and what would they look like as people if all they did was pick a guy out and start to torment him? What do we think of people who do that? What do we think of people who call grown men rapers and pedophiles and predators for kicks? What do we think of those people? They had to come in and say that. Because if they don't, we know what we think of them. That's the reason they came in, and they said this to you guys under oath. They got on that witness stand and swore to tell the truth, and they told you that he said he was looking for little girls. Well, the cops got up under oath and told you, no, they never mentioned that to me. What are the odds? What are the odds that that actually happened and nobody mentions it to the police? What are the odds? Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make any sense to you? He's with his wife. He has lunch with his wife and his friends. In order to believe what these drunk teenagers are saying, you have to believe that he has lunch with his wife, he's with his friends, they're having a fine time. Ariel loses his phone, and Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for little girls. And I'm going to tell a bunch of drunk teenagers I've never met before, that's what I'm doing. Tell me that makes sense to you. Because you get to judge the credibility of what people have said to you. Okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that. Nick said that. They find Ariel's phone in the river. So we know that. We know that Nick comes up to the teenager's tubes, and we know that Cockfield's looking for a phone, and Cockfield's holding a phone. Joanne Cockfield's holding a phone. We know that Nick Miu walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult. So he heads over there to talk to her. And what we know is you can see his thumb. He's motioning back. trying to explain what happened. And we know that Mattison Cohen, who knows nothing about what happened, zero, starts screaming at him to leave. We know that Mattison Cohen feels comfortable enough to put her hands on him for the first time and move him because, well, she's queen of the river and she decides where people go. So she's moving him. We know that. We know that Nick is uncomfortable, so he waits for his group to come over because the state can say whatever they want. He's by himself. So we know Nick does that. We know that when Nick waves to his group, so does Mattison Cohen. But there's one big difference here. Her group shows up. And they show up in numbers. We know that the group of teens are brave. And as this is going on, they start taunting this man who's done nothing to them. We know that. We know that Rhyley Mattison comes over and now she thinks it's necessary because she's been anointed something in the river and she gets to tell him where to go. So we know that she puts her hands on him. We know that Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Mattison Cohen pushes him, puts her hands on him again. He tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick Miu, you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children, I'm going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat, right? And if you think about it, they all blamed. They didn't know it, but the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name. It's like, wasn't me, wasn't me, wasn't me. Well, you're saying it's the one person who isn't here, right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does...
I can't see the exhibits and I'm doing rebuttals.
And step up and go over to the side.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Miu's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're gonna see the video one time, promise, broken up into those parts.
What is he on? Whoa! What are you talking about? What the hell are you talking about? What? Get away from us! What? What are you doing? What's going on with y'all homie? He's on camera. Scripted. He's on 4K. Yo, the new iPhone got that good quality. What do you say? Yeah, what the hell? Who is this? Yes. Further culture. Who is that? Further culture. Who is that? Who the hell is this?
Bro, doesn't matter.
He said he was looking for little girls.
You're looking for little girls?
Yeah.
That's exactly what he said.
Weird us out. I even have that part on camera. Did I? Some young ass kid. What the hell is this guy's problem, bro? We trying to have fun. He's gonna claim you. He's gonna claim you. We don't want this one.
The second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is really the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched. And where Nick Miu has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, you heard A.J. Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay? No one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Juwan Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it sat there. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face? She doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says, if I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Miu pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right? Wrong. They do a Cellbrite downloaded extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother, because maybe she either took the photos or were sent the photos. No, not there either. You get to judge the credibility of people on whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Now, you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be contrary to Nick Miu's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drug teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation, okay? You have to find that Nick Miu committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video is from 150 to 205. Okay? Now, you heard yesterday. The state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24th. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Miu. And if you've watched that video, the first time I saw it, I didn't see that. I didn't see him pulling it. I didn't see some of these people. Because it's moving like this. When you break it down to 1/24th of a second, it's just not how we live our lives. You have to look at those 14 seconds through Nick Miu's eyes as he was standing there. And remember, he told you yesterday that he believed that he was going to die. But he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe, okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds? We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Miu was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Miu was going to suffer serious bodily injury if someone didn't help. Alex Vang told you Miu's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, stop, stop, stop. He's not yelling it to Nick Miu. Nick Miu's tail down in the water. Presumably, he's telling it to the people who are beating him, right? That's what we know. Now, Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Miu's getting punched in the face and knocked in the face, slapped. Okay, but what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet backwards into the water by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Miu while he's still on his back, kind of on his lower, on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that AJ Martin, who says he's the peacekeeper, that's what he said. He runs up from behind and shoves Nick Miu, while Dante Carlson comes in for thirds and smacks Nick Miu in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man, who had heart surgery, is terrified as to what's going on. We know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what AJ Martin said in his testimony, when he was shown the picture of him making contact with Mr. Miu before Mr. Miu stabbed him, he said, he got me before I got him, I guess. What does that tell you about what AJ Martin's intention is? He's back in the water now for a third time after getting pushed down by AJ Martin. And what do we see next? That's Anthony Carlson. He walks right by me. Miu doesn't do a thing to him. Mr. Miu doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Miu has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him. We know that. And then we know 1 second later that Isaac Schuman comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Miu. And why does it matter? Why does any of that matter? Because if you find the following, Nick Miu is not guilty of all the charges. Okay? If you find that Nick Miu believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that. And that's his subjective beliefs. Okay? if he believed the amount of force that he used was necessary to terminate that interference. Okay? So if he believed that he did what he had to do, right? I would submit to you there's only two answers to that. Only two possible answers. He either did what he had to do to survive, or this man who you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm gonna start stabbing people. I'm gonna leave my group, I'm gonna go over and I'm gonna start stabbing. Mr. Anderson says he snapped. If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind. Right? This 52-year-old engineer who's married just lost his mind that day. Those are the two options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is when a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment. Okay? Quentin Carlson is about his age. And Quentin Carlson is concerned enough for his safety that he sends his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? There's a point in that video where Nicolae Miu puts his hand in his head and says something like, my life is over. And Brandy Hart says, I don't know about that. They're self-defense. She says, I don't know what I would have done. But I can tell you I would have been scared shitless. She's been a police officer for 25 years. And that is her risk. State never followed up with her on anything after that. That was her statement to the police. Or that was her statement on the tape. And as I mentioned, Alex Vang and Owen Peliquin say he's getting his butt kicked. They're all over him. Are those reasonable people? You get to decide what a reasonable person would do in that situation. But I would submit to you, you've got something to work with. You've got something to work with. Briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Schuman, and you have to find them for the others involved, okay? And the question on intent is mental purpose. Can you watch that video and say that Nick Miu's mental purpose is to kill Isaac Schuman? Or is his mental purpose to get another person off of him? You get to decide that. Okay? Under those circumstances, you heard everybody say, anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him. He didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything, guys. right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges, with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick. They're telling you they thought it was intentional. Now it might not be. Now it might be reckless. They don't have it. Nick Miu wanted to get Isaac Schuman away from him. He didn't chase Isaac Schuman down. He didn't move toward Isaac Schuman. Isaac Schuman moved toward him. And on the attempted homicide, read the instruction on attempted homicide. In order to convict someone of an attempted homicide, the state must prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have, except for the intervention of another person or some other extraneous fact. Okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard D.A. Anderson say, but for medical intervention, some of these people would have died. Well, A.J. Martin would have. Dante Carlson had a hernia. He repaired a hernia. Sorry, medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from that. And Rhyley Mattison could have got an infection, they said. I understand that. But if he wanted to kill them, why didn't he? If you believe Attorney Anderson, he's alone with Dante Carlson. Why does he stab him one time? He wants to kill him. Why doesn't he smash him up? He wants what he wanted all along, to get away from these people. He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think? What does Nick Miu believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was nothing, no outside extraneous factor, they also say it might not be attempts. Take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video because I think it's appropriate that was played, the interview with Nick and Brandy Hart. He lies about the knife. He lies about the knife. What he and what Lieutenant Hart said is he's never wavered on is that this was self-defense. That he was fearful and that he was being attacked. Okay. That he's never wavered on. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong, some people lie about stuff. He's not telling you the truth about him. But Does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 11 people. Sorry, 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is, right? What has persevered through this case is Nick Miu's fear, how he felt, the shock. You heard people testify about that. The whiteness, the wide eyes, the ghost-looking color of his skin, that has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. You should feel sympathy for Isaac Schuman's friend. I have a 19-year-old son. He would be in Isaac Schuman's grave right now. Everyone feels sympathy for Isaac Schuman's family. I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and evidence. That's what you are required to do. And put most succinctly in terms of the burden of proof and what the state has to do is they have to prove to you beyond a reasonable doubt it's not self-defense. And what does reasonable doubt mean? Well, the judge read it to you. You'll get to hear about it again. But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things, if there is a pause or hesitation about what you need to do because you're getting information from various places, you say, I need a break, I need to figure this out. That's reasonable doubt. Okay? It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this. When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty. If you're like, it likely is, I don't know, not guilty. If you believe it might not be, not guilty. If you believe it's probably not self-defense, not guilty. All of those considerations that you would have require a verdict of not guilty. Because the state has to prove to you beyond a reasonable doubt that it wasn't self-defense. So, as I go to sit down, we, Attorney Nelson, Nick Miu, and I appreciate all of your time. The time that you've taken away from your families and friends to do this. The attentiveness that you've given us. And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Miu home. That you find him not guilty on all of the charges. Thank you.
While we swap people out, if you'd like to stand and stretch for a moment, you may do so. And then we'll hear a brief rebuttal from Mr. Smithstone.
you just heard Mr. Tropsy say his entire defense is based on what Nick Miu told you during his testimony was thoughts in his head, the beliefs in his head. What do we know about Nick Miu? We know he's smart, speaks multiple languages, has a couple of degrees, one's in math. He's a calculating person. He's a cunning person. He's a skilled and prolific liar. We know that because every word that came out of his mouth, practically since he started walking away from this group, was a lie, including to his best friend, who he said they took my knife while the knife is still on him. The things he said to Sheriff Knudsen, where he pretended to not know what was going on. And then everything he said to Investigator Hart, Lieutenant Hart. He is skillful at crafting a story that matches what he needs to say to avoid the consequences for his actions. We all know that. It's undisputed. He told you himself he's a liar. All right? He did not just not lie about the knife. He lied about all kinds of crazy things, bizarre things. Why would he say that these boys pulled his pants down? What a bizarre lie to make up, right? Why would he say that two boys pulled knives on him? He's got to say that because he knows what he did wasn't justified. He thinks to himself, if I say one boy pulled the knife, that would be good, but if it's two, that would be better. So he crafts this elaborate story. His entire defense rests on you believing what he said on the stand yesterday. His testimony was a disaster. He got caught in several lies on the stand. He changed his answers a couple of times when he realized that what he said wasn't helpful to his defense, right? He consistently remembered details from July 30th, 2022 that benefits his defense, but doesn't remember anything about what he did, any of the facts, any of the stories that he told Lieutenant Hart. How is that possible that he can only remember the facts, the beliefs he had that assist his defense, and nothing else? How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated it over and over and over again because he doesn't want to answer questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying. One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was the fault of these boys. That's ridiculous. It's despicable. There's never been any explanation from the defense as to why Nick Miu ran up on these boys, why he grabbed their tubes, why he was groping around where their legs were. They don't even respond to it. They didn't bring it up. There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault. These boys have beat themselves up every day since this happened. You saw the raw emotion on the stand. Their best friend was murdered by this guy. And to say that it's their fault is despicable. Nobody's responsible for Nick Miu's choices but himself. He chose violence at every turn. There's been some question about whether he's fragile. Part of him is fragile. His ego is fragile. As his attorney had said early last week when he's questioning these boys, you were trying to humiliate him. You were trying to insult him. You were taunting him. He was humiliated. He was insulted. He didn't like these boys treating him like that. He certainly didn't like Madison Cohen getting in his face, so to speak. And eventually, he did just snap. He pulled his knife out, getting ready for violence, pulls it out, holds it down where nobody can see it, holds it at his side, and then hits her. That started the violence. He prepared for the violence before he started it. He felt humiliated and he wasn't going to let it go. I asked him, did you ever take a step back at any time when she was yelling at you? No. With no explanation. We're dealing with what we call false narratives in this case. Things that the defense repeats over and over and over again, hoping that you think it's fact, okay? One of these is this 13-to-1 narrative, okay? We've heard it 100 times in this trial. This is not a 13-to-1 situation. We've got the 6 teenage boys standing on the side by their tubes. He's confronted by the 2 girls. Everybody else is in the background. He hits Madison Cohen when he's only got 2 girls standing in front of him. After the fight, it's 1-on-1 to start. It's Dante hitting him, and then arguably 2-on-1 when AJ comes up and pushes him in the back. Tony breaks it up. The fight's done. He gets off. And AJ, of course, is already tore open, so he's laying in the river. But that's the end of the fight. Mr. Miu continued violence. He chose more violence after that part of the fight was done. Tony, who did exactly what his dad told him to do, came up to try to break it up. You can hear him telling Dante, his brother, get away, get back. Mr. Miu turns around and stabs him, and Tony blocks it and stabs him again. He chose violence at every turn. There's another false narrative. They circled him. They surrounded him. Baloney. You've seen the video how many times there's open water everywhere. That he was attacked from all directions. False narrative. He said that Owen Peliquin testified that they stuck around because they wanted to see how it played out. That's true, but what he didn't mention is that Owen also said he wanted to make sure he didn't do anything to this woman. And you know what? Those instincts were exactly right. Those instincts were right. He keeps talking about how these boys wanted to make a video. Well, they were making a video. But what does that matter? They didn't start the violence. None of those boys laid a hand on him, despite the fact that he touched both Joanne Cockfield and Landon Wire when he ran up on them in their tubes. Nobody laid a hand on him until after he had already stabbed a number of people. Isaac Schuman tried to stop him. He got killed for his efforts. He seems to be arguing, the defense seems to be arguing that Isaac somehow deserved it. I don't understand that argument. He's trying to protect people. He calls Maddie Cohen the queen of the river, and he calls her a bully, calls her a number of other unkind things. Her testimony was, and it's clear from the video, she was trying to protect these boys. She saw that he was over there doing something, but it was freaking them out. She tried to protect them. You know, maybe if we had more people on the river trying to protect people, the world would be a better place. They've made, over and over, they've argued that Maddie was never punched because she has no marks on her face. Nick Miu, who, as Mr. Trofsky said, was lifted off of his feet by the punch from Dante and punched in the jaw and fell in the river, gets up and there's no marks on his face. We have pictures from him. We have the video. We have his interview with Lieutenant Hart later. We have the pictures that the jail nurse took 5 hours after. There's no bruising. There's no puffiness. There's no swelling. The fact that they're arguing that Maddie had no mark doesn't matter because he didn't either. It happens. They're trying to say that he was terrified. His face tells a different story. He has expressions of anger. He has expressions of, I guess, humor. He's smiling. He's smirking. Well, after he has his knife out, he clearly feels comfortable. There's no look of terror in his face at any time. KJ Martin was not armed. He pushed Mr. Miu in the back. We know that. He didn't kick him, he didn't punch him, he didn't hold his head underwater. He pushed him in the back. And for that, he got a incision on his body from his belt line all the way up. You saw the pictures. It's horrible. He used no weapon against Mr. Miu. They made a big deal about Lieutenant Hart telling Mr. Miu in the interview that she would have been scared too. Well, she made that response after he'd been feeding her a load of BS about all this stuff that supposedly happened. About having two kids pulling knives on him and pulling his pants down and all the baloney that he fed her. Based on that, she said, yeah, I would have been scared too. They're arguing that he had no intent to kill Isaac. Isaac weighed 134 pounds at the time. He's 250. He rams his knife up, not down, up, severing two of Isaac's ribs right into his heart. All right? If he didn't intend to kill him, why not stab him in the belly? Right into his heart. We've heard no explanation whatsoever as to why he stabbed Rhyley Mattison. We know from the video she's standing off in the background after Tony's trying to break it up. He just walked over and stabbed her. She wasn't attacking him. They don't explain that because there is no explanation. None. He wasn't in fear for his life from Rhyley Mattison. She said she was 110 pounds now, might have been 115 back then. There's no fear for his life. He just was mad because she touched him. They've talked a little bit about extraneous factors. It's not just medical attention that can be an extraneous factor. As we know, multiple people on the river stopped to help these folks, putting compressions on. One witness said they used a sandwich bag to try to make a chest compression. There was a lot of interventions for these folks. We know with Rhyley Mattison specifically that Larry and Davis and his brother, we saw it on the video, got her to shore on a tube. People went out of their way to help these folks. These are extraneous factors. But another extraneous factor is he just got unlucky. You know, if he, as Mr. Anderson had said, we've got arteries, we've got organs. Dr. Meyer said, you know, whenever you have an abdomen wound, you have to check all those things. It's kind of a miracle that more people didn't get killed. It's not by anything he did. He just got lucky. Missed major organs and arteries. The bottom line is he had 4 hours from the time that he was arrested to the time that he concocted this ridiculous story about the boys pulling knives on him and pulling his pants down and all this other bizarre baloney. He used his intellect, because we know he's smart, to craft this story. And he was very deliberate and detailed because he wanted to come up with a story that he thought would be sufficient to convince people that he acted in self-defense. We know he lied about all of it. So now today, he's saying, well, sure, I lied about everything I said when I talked to Lieutenant Hart about what happened, but now I'm telling the truth. So now believe me. No. You have my full confidence. I know you're going to return just verdict of guilty and deliver justice to Isaac Schuman and everybody else who got hurt by this man. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors. selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether Mr. Miu is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide, and they must not affect your deliberations. Multiple forms of verdict will be submitted to you concerning the charges against the defendant, Nicolae Miu. For count 1, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of first-degree intentional homicide as charged. Another form, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of second-degree intentional homicide as submitted. Another form, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of first-degree reckless homicide as submitted. Another form, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of second-degree reckless homicide as submitted. Lastly, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu not guilty. Return only 1 for your verdict. If you return a guilty verdict, you must also answer this question. Did Mr. Miu commit the crime while using a dangerous weapon? As to count 2, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted first-degree intentional homicide as charged. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted second-degree intentional homicide as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of second-degree recklessly endangering safety as submitted. Finally, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu not guilty. Again, return only 1 for your verdict. If you return a guilty verdict, you must also answer the dangerous weapon question. As to counts 3, Dante Carlson, count 4, Anthony Carlson, and count 5, Rhyley Mattison, the court will give you 5 verdict forms for each count that are worded similar to the ones given to you for count 2. As to count 6, Madison Cohen, 2 forms of verdict will be submitted. One reading, as to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu guilty of battery as charged. Next, as to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu not guilty. Again, if you return the guilty verdict, you must answer the dangerous weapon question. It is for you to determine whether Mr. Miu is guilty or not guilty of each of the 6 counts submitted to you. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, please administer the oath to the bailiff.
Do you swear that you will, to your utmost ability, keep all jurors on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict and that they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
The bailiff has extra copies of the jury instructions. I imagine you'll probably want to consult with them during the course of your deliberations. I believe he has 4 or 5 sets. If you need more, let him know, and I will print more for you. He also has the verdict forms in each of the manila envelopes, 1 envelope per count. If you reach a verdict, please put that verdict signed by the foreperson back into the envelope. The other forms that you don't use can be discarded, but there only should be 1 verdict form returned back in each envelope. Now, members of the jury, as I mentioned to you at the beginning of the trial, only 12 jurors can deliberate. 2 alternates were seated in the event that we lost jurors due to health, emergency, or some form of misconduct. The alternates have been determined by lot by the clerk of court. The alternate jurors are not released from jury duty. Alternate jurors may be called upon to deliberate if we happen to lose one of the 12 jurors during the course of deliberations. So basically, the alternates are needed to be at the ready and stand by in the event that they are needed. The alternate jurors will be free to leave the building, but you may not talk about this case with anyone. You may not research or investigate the case on your own. You may not read social media posts. You may not read news reports about this case. If we need an alternate juror to participate in deliberations, the clerk of court will contact you. So we'll need a phone number before you leave. You will be expected to return relatively quickly. So please stay close to home or close to your place of work if it's nearby. We will keep your personal notes safe in a secure private location in the event that you're called upon to deliberate. At this time, I'll ask for the envelope. The 2 alternate jurors are Darren You may. If you'd like to have a private place where you can eat it here in the courthouse, we'll provide you with that facility. But the alternate jurors may not eat with the other 12 because the other 12 may begin their deliberations once they are back in the deliberation room. Please take the jury out.
All rise for the jury.
Please be seated. Mr. Anderson, do you have any objection to the manner in which I read the jury instructions?
No.
Mr. Trofasi, do you? Yes, sir. All right. The alternate juror forms, or the alternate, I don't know what you call this, the jurors selected for 12 the 12 jurors selected for deliberation are listed on the form if either of you need to see it. The clerk has it, you may look at it. Before we adjourn, attorneys, please stay close by in case there are questions. I do want to compliment both of you, actually all of you, on your conduct and demeanor during the course of this trial. It is difficult subject matter. It is difficult law to get your mind around. These were tragic events, traumatic events, and I thought you carried yourselves with dignity during these proceedings. And I think your clients, the victims, and the community should be proud of the way that you have administered justice today. You both have given this jury a lot to think about. We stand in recess.
All right, everybody. So we have officially concluded the trial. So here we are, guys. So looking at our poll, we are at 68% not guilty. And looking over at the Law and Crime channel I'm looking at right now on my phone, there's over 50% of the chat there believes it'll either be a hung jury or not guilty. So good stuff there. And Judge, I had no problem on that. I wasn't certain what you were saying there, so no problem. I wanted to, like I said, I didn't mind engaging. And then when we saw the cussing, I think we thought, well, do we have somebody coming in here trying to be disruptive? Because I don't mind talking to people, about all. We want all opinions here. I want to hear from people that think that he's guilty and hear what you think and what the reason why is. Because to me, in this case right now, I don't think, I just cannot imagine this jury finding him guilty. I think it's if these are reasonable jurors, the final argument, that was mind-boggling. It's like he was living in a different world than the one that we reside in, watching different videos where Mr. Miu is some crazy knife-wielding madman who's just decided, I'm going to end my life as it existed today. And I wish that would have been really honed on a little bit more as telling the story. It's like Nicolae Miu, look what his life was. What motivation would he have to decide today, I'm going down to the river and I'm going to find me some kids to stab? I mean, it makes no sense. But what does make sense is he gets surrounded by a group of drunk kids accusing him of being a pedophile, accusing him of some of the worst things you can be accused of in this world, frothing up the anger levels to a point that he gets surrounded on the lake. I mean, where does Prosecutor Anderson think he was running? When you watch that video, he couldn't go anywhere. I mean, the way it was, and the thing is the way it was happening. It's like he didn't have the time to make the decisions that the state is claiming he could have made. It's insane. I understand the outcome was horrific. I understand the outcome resulted in some really terrible injuries and a terrible death for a young man. But in that moment, when you hear Mr. Cockfield laughing and yelling and thinking it's great that this guy's getting beat up and knocked around like a rag doll in the riverbank, and he's a 52-year-old man that just got done with a massive heart surgery, and and then he leaves. Well, what do you think he's going to do? He doesn't. He just knows this. There's a gang of kids that are claiming that he's a pedophile and all this stuff. Do you think he's going to hang around for the police in that scenario, or do you think he just says, "I want to get the hell out of here"? I mean, everyone on that riverbank is thinking that he did, according to those kids that are going to continue chanting and continue, they're going to be a bloodthirsty pack of crazed people because he knows, he's just had to stab a couple of them. Jaja says it's a sad world we live in. It's a shame living here in Hawaii. You get the book thrown at you and locked up for defending yourself. Well, it is. And Um, no problem. It's okay, J9. But it's it's just this case is very disturbing in so many levels, and it parallels nicely with the Crumley case. And for those of you that are not completely familiar with the Crumley case, I would recommend you take some time when you have. Of course, there's so many cases going on. We've got the Karen Reed case coming up next week. Chad Daybell just began. We've got so much going on right now. As far as cases, it's almost tough to go backwards. And we'll have the Tyrone Tucker case coming up in May. And there's, of course, the YSL case. I mean, there's just so much going on right now. Things are heating up because we're getting into that part of the year where they're going to start really trying a lot of cases. But the Crumley case is particularly disturbing because you have a situation where, if you really want to understand the crux of the Crumley case, what they've done is they've taken the involuntary manslaughter law and they basically enlarged it to try to encompass the facts of the Crumley case when it wasn't intended to do so. And the result is that they created a new standard after the fact. Karen McDonald, if you got to understand Karen McDonald, she's the prosecutor and of that case, and she has political ambitions, and she basically set out to decide, what, these parents, she found out these parents bought a gun for their son, or at least a gun was bought by the father. Now, it wasn't really bought for the son. The son thought it was. They told him it was a Christmas present. But if you look at just that fact alone, it sounds really ominous. But then when you put it in context, and you put it in context of what they argued in his case, that that the son was a troubled kid, and you look at the fact that what they're saying is that the signs of trouble that they allegedly ignored was 7 months prior. The thing that they don't put together is that essentially the guns didn't start becoming something father and sons were doing until after those messages, meaning this was in reaction to Ethan Crumley's troubled state because he was exhibiting signs that he was upset, that he was depressed, he was upset that his grandmother died. Nothing that he was going to do a mass shooting. Now, you have to understand, the community that Ethan Crumley lived in, going to the gun range, learning about guns was something that was just a natural part. At the school he went to, it was not uncommon that they brought guns for homecoming pictures. And as a result, father and son, they're learning about, he's teaching them about gun safety, and they buy a new gun, one that they'd been wanting to go shoot at the range, like 5 days before this happens. So they have no reason to believe that he's going to be doing a school shooting. There's nothing indicating that. They'd encouraged him to write in a journal about his thoughts and they were trying to encourage him to get good grades. They knew he wanted to be a video game designer. I mean, these parents were doing everything that parents would do. I mean, they were humans, and they were not perfect humans, but they were certainly not neglectful to their son to the degree that the state alleged. But Karen McDonald heard about the fact they bought the gun. She's made it very clear. And at that point, she went to work and said, how can we stretch the manslaughter law? And the reason why this is similar to Miu is because essentially what she did is she looked at the outcome, and she used the outcome, the horrible carnage of the outcome of that case, to argue it to the jury. And they ended up this defense was willing to stipulate as to what happened in that school, because that really wasn't what the case was about. It was about everything that happened before that. But the prosecution in both cases for mom and dad wanted to play the videos. They brought in the witnesses. They brought in the victims to testify about what their son did in great detail in order to inflame this jury and make them not think about the law and not think about whether or not they actually whether the law was actually violated. And that's similar to what this prosecution tried to do, not as effectively, I might add, because this is a totally different, unfortunately for Mr. Miu, it's a totally different set of facts. But it's similar to what they tried to do. They basically said kids got hurt. These kids, it's and that's why they ended up, pursuing. So let's see here. Let's see what you guys are saying here. So appreciate you guys' support. Yep. No, I agree with you. I don't think. Well, I think listen, Mike Maloney. I don't think if he doesn't do that part, I don't think he ends up charged, or at least I don't think. I think they might have come to a different conclusion, possibly. But that allowed for them the extra ability to argue, because you saw one of the big arguments Anderson made was how he acts afterwards, the callous, the calmness. But it doesn't make sense. It doesn't make sense. I mean, even the judge says it makes no sense that he would just decide today is the day that I'm going to wreck my life and kill kids on the river. I mean, that makes zero sense. So, Laura, is your question, what are we going to be covering after Miu? Well, my plan for that is I have an equally good case, I think, that we're going to cover if it goes to trial. We'll be looking in on the Daybell case, but next week begins the Karen Reed trial. It's a very controversial case out of Massachusetts. It's one where they're claiming, her defense claims she's being set up. It's a case where she is alleged to have ran over her boyfriend, who was a police officer, in their driveway. Similar to the first case I ever covered on this channel. But it's similar in that sense that she was alleged to have ran over the guy. It's not similar in the way her defense is going to go, because in that case it was self-defense due to domestic assault. In other words, he was beating her up. She pulls out. She's trying to get away. That's how the original case. That's how the first case I'm referring to it. In this case, they're claiming that there was some sort of cover-up or conspiracy, and she's being framed. There's going to be later today. There's going to be documents released. So I'm going to be getting a hold of the motion to dismiss that was filed, the full contents of it, which I don't believe was released originally. We're going to read through it in preparation and get ready for it. But it should be a very good trial to cover. Like I said, the Daybell case is going to be going on, but it's one of these cases that's going to go on for a couple of months. And I prefer to cover, like I said, the Reed case. We will look in on, I will continue to look in on the Daybell case. We'll continue to stay up on it. We'll do some secondary coverage on it and watch it just to see what's happening with it. But the real main event right now is going to be the Karen Reed case. So that's one, if you guys want to read up on it, if you're not familiar with it, I'd encourage you to check into it. We're going to be doing some prep for it as well. And then after the Reed case, I think we might have the Treehouse case technically, or it's tentatively set for May 14th. The Reed case is expected to take a couple of weeks, but that's going to be a really controversial one. That's one that everybody is anticipating. And then there's going to be other cases that Law and Crime will throw our way, and we'll figure it out. That's right. Now, Jaja, how long do I think it'll be until a verdict comes out with the complicated jury instructions? I think you're talking about probably, they say rule of thumb is normally for every full week of trial, a jury will be out for 8 hours. So we've had a week and a half. So that would mean it would not begin to become unusual for this jury to not be out for at least 12 hours, which would mean the rest of today, probably, what are we at in their time? Because remember, there's a time change difference. It's 1:42 in the afternoon. I believe they've been deliberating about an hour, hour and a half, 2 hours. So I would say probably we would see them maybe go through the dinner time tonight. The judge insinuated that was possible if they wanted to do that. I think you're going to see the rest of today deliberating, and you could see the rest of tomorrow. I think the verdict will come in probably sometime tomorrow afternoon, unless they get back there. Now, it will not be good news, I don't think, if this jury gets back there and comes back in like 4 hours. Then that's going to be indicating that they went back there and said guilty. What you want in this case, hour and 15. Thank you, Jeff. So, now, one thing I'm going to pull up here, I want to watch this is courtesy of Laura Connor. We're going to watch the missing witness. So let me pull that up right now, and we'll watch that because it's interesting. I've got the video here. Give me a moment. All right. Cohen is the missing witness. Yep. Give me one moment here. And we'll pull this up.
A witness in the Apple River stabbings case who didn't want her testimony seen or heard could be the person who tips the scales. Madison Cohen's altercation with defendant Nicolae Miu is what sparked the incident that turned deadly. Now, Cohen says that she confronted the defendant after she saw a group of teenagers yelling at him. Body cam video of the aftermath is the only glimpse we see of her. Take a look.
He punched me in the face. I don't know what the got someone who can't move. Go help him. Please. We're going to help. We got a gentleman down there. His guts are out in the open. Okay.
A transcript of Cohen's testimony lays out what she says about who threw the first blow. So on direct, she said, he strikes me in my left side of my face with his left hand. And the question is, did he hit you with a closed fist or an open hand? She said, I can't remember. I thought it was with a closed fist. And the question is, you don't remember like seeing it coming in though? And she said, everything happened so fast. Then later on cross-exam, the question is, okay, so he throws it with his left. He throws a hook with his left hand, is that right? She said, yes. And he said, and I think you testified that he hit your left side of your face. She said, yes. Question is, okay, so he hit you on this side. Describe how that's humanly possible. Her answer, I actually do get my lefts and my rights mixed up a little bit. Okay, is that gonna be a problem? Let's bring in our guest and talk some more about this. Criminal defense attorney and former elected district attorney Matthew Mangino. Oh, Matthew, what'd you think when you hear that?
Well, that doesn't sound good. It's not a good look. You obviously can't get hit on the left side of your face with a left hook. Now, she tries to explain it away by getting my rights and my lefts mixed up, but I would have made her demonstrate how this happened. So if she throws with her left, obviously she's going to realize that you can't get hit on the left side of your face. So she may have explained it a little better. I don't know if there was a demonstration of that blow or not, but that certainly would have helped clear it up for the jury. If she was just testifying and she says, I got hit on the left side of my face with a left hook, the jurors are going to pause. They're going to say, wait a second, that's not possible.
Right, Matthew. I love what you said there. And there was not a demonstration. We went all through the transcript, and you're right. That could have really helped clear it up, and then maybe she would have made better sense. I'm not saying she's lying. I'm just saying, that's not good that she's saying, she's an adult woman and saying, I get my left and my right confused. Let's look at a little more here. So this is from a point in the transcript where she's being questioned by the prosecutor, and she's talking about how she did make contact and put her hands on Nicolae Miu.
She's asked, what did you do? And she said, I graciously grabbed the corner of his elbow and I got him back toward me instead of those boys. Did you yank him? No, sir. Did you and Rhyley's another one of the girls involved in this, did you both touch his shoulders? Yes. Shove him? You didn't shove him or hit him, which is actually an objectionable question there, as you know, Matthew. And she says no, because the defense is saying that she did shove him and was pushing him, and that the strike that he delivered to her was a defensive strike. Oh my, this is messy, isn't it, Matthew? How does this get sorted out for the jury? And I think for all of us at home struggling with not seeing her, and she's not on the video. How much do you think that might matter, Matthew, for the jury that this incident wasn't caught on tape?
Well, there's no question that jurors, like to see videotape that genuinely shows exactly what happened. There's a lot of videotape here, but yet there's no videotape of this encounter. We didn't get to see her, we didn't get to hear her, but the jury did. So the jury has that ability to determine her believability or credibility. And that's what every case comes down to. Do you believe what this witness is telling you? Is this witness credible? And they can make those judgments. We can't. We haven't had an opportunity to see it. But again, we have to remember that self-defense, is it reasonable? Is your conduct reasonable? Did you need to use lethal force? Did you believe you were in danger of serious bodily injury or death? And that's really what the standard is here if we're going to talk about self-defense in this case.
Right, Matthew, thank you for that. Serious bodily injury or death, got to be imminent, as you said. What was his belief at the time? I do have a clip I would love to play for you now. This is from witness Rhyley Mattison. So she's friends with Madison Cohen. She calls her Maddie. So Madison Cohen, the woman who chose not to be on camera, but Rhyley was okay with being on camera. And she really does corroborate the story that Madison tells. Let's take a look.
Do you remember everything sequentially perfectly, or is it
It's very choppy for me.
Okay. So what do you remember next?
I remember getting off the tube, walking up to Mr. Miu, and I just remember Maddie being in there and yelling at him. I remember her being punched in the face, and then I remember being stabbed, and that is completely it.
Okay, Matthew, how much does testimony like this help?
Well, certainly it corroborates what we've heard from Madison Cohen, that in fact, this whole incident was precipitated, certainly the physicality of it was precipitated by him punching her in the face. And that is consistent with her testimony. And it's helpful for the prosecution.
Right, Matthew, it certainly reinforces their position. We'll leave it there for now and go in there live this morning when they start back up. I want to say a big thank you to Matthew Mangino for his time and expertise this morning. We'll see you soon. And that's all for this episode of Opening Statements. My friends, you can watch it or share it again if you like. Just go to courttv.com to do it.
Mr. Nelson.
Thank you. Can I have the screen? Mr. Miu, when we...
All right, so there you have it. That's the missing testimony. I think graciously, I agree, Jeff, graciously grabbing her. I don't think, based on what we saw in that video, there was nothing gracious about anything that was going on. She comes flying across the river. She's yelling. She's screaming. She's cussing. There's no way in the world that you can do it. Well, I know. And Julie Grant is a very prosecution biased individual. So is Vinny. I mean, they're all former. A lot of the hosts are former prosecutors or judges that were former prosecutors. So you're going to get a slant. I like to watch it for the simple fact that it's interesting to. It gives me something to argue about or yell back at my phone or TV or whatever motive medium I'm watching from. But at the same time, I'm like I don't understand why she didn't want to be on TV, except for the fact that I think she knows that her story is bunk. I think she knows that it's absolute. She was going to come up here and lie, and I think she didn't want her face put in with this because she knows she's the reason why this happened. What's that, Laura? Update on it. Is Mr. Miu? Nothing yet. It's still deliberating. The jury is deliberating. I think it's been now close to. I think the last time it's probably been about an hour and a half of deliberations at this point. I don't expect, Laura. I mean, obviously anything is possible when you're dealing with a jury, but I don't believe we're going to get a verdict today. I think it'll be tomorrow before we have a verdict, because I think the jury will be dismissed to go home at some point today. And that's what I think is going to happen. I think we'll probably get a verdict at earliest tomorrow. As I was telling everyone, the typical rule of thumb for jury deliberations is 8 hours of deliberations for every week of testimony. And we had about a week and a half of testimony or trial, or I should say not testimony, trial. So we had a week and a half of trial. I would say we're talking probably 10 to 12 hours of deliberations is what this would normally result in. Most cases follow that if you follow them and look at how long the case is. Now, some of the longer cases can obviously maybe not meet that exact standard. But in this case, I think you're going to see some debate. I don't think you're going to go back there and find 12 people agreeing on everything. You could. I mean, you could have 12 people back there that watch this video like we do and say, you know what, that video says it all. It's not guilty. Because remember, if they believe it's self-defense, then all of that complicated jury instructions doesn't mean anything. But that's provided that you get 12 people to say it's self-defense right away. And I don't think you will. I think you're going to get, but I think in this case, I think you're going to get a majority in that room, I think, will believe it's self-defense. There's going to be a few they're going to have to work through, and they're going to make arguments mainly about the fact that I think their struggle is going to be the kids. Now, that's whether then you run into the problem of are some of the not guilties willing to go and say, well, maybe I could do not guilty of, a lesser included offense. And then you start to run into a case like this where it falls in the middle, where they go, well, you're right. He probably shouldn't have done this, or he shouldn't have done that, or yeah, you're right. He couldn't. And again, some of those stills in the ways they've argued it, you might get somebody in that jury room who says, I believe he just really wanted to, I believe he really wanted to stab these kids because he was upset. Like, in other words, it's not a far stretch that you could find somebody in there who might think to themselves, yeah, if I was being called a pedophile, I'd get mad. And that he then ends up in a, that he ends up going in and, engaging with these kids. And then Mattison comes over and he's just, again, remember, the argument of the state is that he's over here, he's being called things that are going to inflame you, right? Which, again, Mr. Miu should have said and been clear on it. He said, remember, and this is the disturbing part, and jurors will remember these things. They're not like us where they're getting a whole lot of various different mediums of information, and they're not able to just rewatch things and talk with each other. But he said he was frustrated, and a juror back there could definitely sit back there and say, man, he said he was frustrated. Does frustration turn to anger? And Madison Cohen comes over and he's so frustrated because he's being called a pedophile. He's acknowledged that he's trying to make, I don't even understand what his argument was. Well, if I'm a pedophile, why are you drinking on the river? I mean, what the hell type of an argument was that, Mr. Miu? But anyways, luckily we don't have to find that his argument was persuasive in what he was trying to say back. But he's trying to argue back with these kids. He admits he's frustrated. So is there a juror in that room that's sitting there going, yeah, he got so angry in that moment, he punches Madison, and at that point the boys jump on him. Well, the problem becomes then, when the boys jump on him and hit him and they're defending Madison, now you're getting into a split verdict territory. Because, see, the stabbing of Dante is not covered under self-defense because they were trying to react in defense of her, and he stabs Dante. Now, if they were to view that others come on top of him and start beating him up, then you might get a situation where, depending on what they believe Isaac was doing. Now, that's why if they're, a guilty verdict or a mixed verdict, this thing could go a lot of different ways when they get back there. But what we hope is that they've just watched the tape and they look at the statute and they look at the fact that, and they view this correctly, and somebody back there sits back there like I did when I was on a jury and said, listen, first thing I read to everybody back there, I was the foreman of the jury, and I said, we have a presumption of innocence, and this is where we need to lead from. And that's where we began. And when I got back to the jury room and I was on a jury, it was 10-2 guilty. Okay. It was 10-2 guilty. And we worked together and we didn't find the individual completely not guilty because I didn't feel was where it was at, but we found him guilty of a lesser. Now we didn't know what the outcome of that meant, but it ultimately meant that the individual, he had been serving time for so long that he ended up walking out of the courtroom. But that's where we started from. But when we went back there, it was, hold on. We've got something going on.
For comments? The 9-second video. I guess a request, really. They'd like to see. All right, we are back on the record, State versus Miu, with the attorneys and Mr. Miu present in the courtroom. The jury has a question. I guess a request, really. They'd like to see both of the Juwan Cockfield videos. Mr. Anderson, your comments? The 9-second video that's been played multiple times. It's only 9 seconds. The other video I don't think has been played in entirety, only once. So I don't have any objection to the main video being played. Mr. Trofasi?
Judge, if you may, not sitting in the right seats, I apologize, but if it's played, I think they need to be brought into the courtroom and it
Yes.
needs to be played in here. That.
My judgment, the jury is entitled to see the evidence, and this has been a multi-day trial. There's lots of things to consider. There are lots of nuances in the jury instructions. So I think it's reasonable for the jury to re-examine exhibits. They can't have the video in the deliberation room, so they'll have to come out into the courtroom to see it. If the jury thinks that watching both videos will be helpful to their deliberations, they're entitled to see both videos. So we'll have them brought back in and we will play them both. I'd like to have the videos played in chronological order. So we'll start with the 9-second video, watch it, and then we will move on to the next video. Now, when they come in,
I think this is a very good thing, guys. Very good thing. It might be a quicker verdict than we think.
Comment or discussion, the opportunity for persuading the jury is over. I may ask the jury if they want to see it again because it moves fast. So if they want to see it again, we'll play it again. But I'll be the one doing the questioning. Any questions about the process? Who do you want to play it? It doesn't matter.
I don't have my computer, so I'm happy to go get it, but.
I can do it. Okay, so you'll play the video. I'll give you the cues to start.
And I'm sure Your Honor will, but I would imagine when they come in, Your Honor is going to tell the jury as well that this is not the time for questions and answers.
Exactly, right.
Excellent, perfect.
All right. We stand in recess until they come back.
Do I have time to go out or not? Should I wait?
Why don't you wait? I think
Okay,
this won't
that's fine.
take very long.
All right, guys. So this is huge. This is huge. I think it's also interesting that they don't have the video back in deliberations, which I can't believe. Well, I think they are debating the video evidence, but I also think that again, I think what it is, yes, I think there's one person back there who's probably saying, what this tells me is a majority are for self-defense. This is what I think. And I think there's a straggler or two back there who have believed, maybe the one that was asleep, who believe that they have heard something that would lead them to believe that you're right, Jeff. Maybe that he said something truly about little girls. And I think, I think people back there are making the case. Look, here's the other thing that I think they want to see. And this is the part. See, we've watched that video. We have access to it. It's on my channel. It's on other channels. One of the biggest things that's going to be debated here is, did he run up on those kids? And I guarantee you, if there's a guilty person back there, he's saying, well, he ran up on them kids. And they're going to say, no, he didn't. The kids were heckling him. This is to settle that debate. And I guarantee you, if that's what's going on back there, then this could be a quick verdict. And not because probably because there's really not much to debate if they're leaning towards self-defense, and it's cleaning up the few loose ends who are sitting back there going, here we go. All right, let's get back in.
All right, please be seated. All right, we are back in session. The jury is present with the attorneys and Mr. Miu. We did receive your request to see the Juwan Cockfield videos. This is not the opportunity for persuading you or for adding new arguments. So the attorneys are not going to comment. We're essentially stepping into your deliberations, but you are entitled to see these videos, so we're going to show them to you, but you won't hear from anybody else. We're going to start with the 9-second video because that was the first in time sequentially. We will play it from beginning to end. I will check and see if you want to watch it again. We can replay it. Once you're satisfied with that video, then we'll move on to the longer one. And we'll do the same thing. If you want to watch it a second time or a third time, we can. But we're going to run it from beginning to end in real time. Are you ready?
Yes.
All right, let's pull up the video.
Man, trying to have sex with little girls. What the hell?
Hold up. Start over, please.
Grown man trying to have sex with little girls. What the hell?
Yes. All right, action.
Grown man trying to have sex with little girls. What the hell? What the fuck? Out! He's a raper. Whoa, whoa, whoa.
Anybody want to see it again? No hands. Let's move on to the next. One more time? Okay.
Grown man trying to have sex with little girls. What the hell? What the fuck? Out! He's a raper. Whoa, whoa, whoa.
Anybody else? Okay. Let's move on to the next video then.
I agree with you, Jeff. It is very disturbing. I thought they would have it, and most of the time they get a laptop. Most states would give them a laptop and let them have it back there to discuss and watch as much as they want. Very odd, in my opinion.
That's fact. What is he on? Whoa! 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 Get away! Whoa! We up! We up! What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all, homie? He's on camera, tripping. He's on 4K. Yo, them new iPhones got that good quality. What did he say? Yeah, what the hell? Who is this? Yes, yes, yes. For the culture! For the culture! Who is that? For the culture! Who is that? Who the hell is this? Go. It doesn't matter.
He's
Go.
running.
Go.
He said he was looking for little girls.
Go.
He said he was looking for little girls. Yeah. That's exactly what he said. Weirded us out. I even have that part on camera. Dead ass. Some young ass kids. What the hell is this guy's problem, bro? We trying to have fun. If he's gonna claim you, he's gonna claim you. We don't want this motherfucker. Let it on camera. Let it on camera. He on camera. Oh God. Oh God, he on camera. Oh God, he on camera. He ain't a woman. He ain't a woman. You ain't a woman. He ain't a woman. You killed him.
What the fuck?
What
the fuck?
Wait.
What the fuck? He's dying. He's dying, bro.
Wait, what? What?
Oh my god. Oh my god. Oh my god. Oh my god.
Are we serious? Is this real?
Oh my god.
Who is that?
Oh my god.
Is this real?
Wait.
Is this real?
Oh my god. Oh my god. What the fuck?
Is this real? Is this real?
Fight. Bro, fight. Fight.
That's not bike. That's not bike. That's not bike. That's not bike. That's not Isaac. Oh my god. Oh my god. This isn't real. This isn't real.
Anybody need to see it again? Want to see it, the entire? Or do you want to stop it at a certain point?
I'd like to stop. I'd like to see the beginning, the middle, but not the very end.
Not the very end? Let's take the video down. Mr. Anderson, if you can get the video, I'll put it, I can see it on my screen. They can't see it up there. Put up the video. And
Absolutely, Jeff.
I'd like to get it to a
Absolutely.
point where I can.
So I told you, I think everything is
See it
hinging on the beginning of that. But see, to me, what I would be arguing is, and what I didn't see the defense do is it's almost two separate incidences. When he runs up on them, that is separate. He leaves. They come around him.
My mistake.
So there's just no way you're going to make the case to me. It should have been. I don't know. I feel like the run up is separated from what happens after that.
That's it.
Because there's a cooling down. He walks away. It's not all in the same event.
25 seconds. 27.
Let's see what they end at.
All right. Let's put it up.
Yeah, that's fact. What is he on? Whoa! 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 Get away! Whoa! Oh God! We up! We up! What are you talking about? What the hell are you talking about? What? Get away from us!
So I think the question is, they're going to be asking, what was he doing when he ran up?
Tripping.
But see, he walks away. So to me, it's separated now from that run up.
What did he say?
And then they're amping it up again.
Yeah, what the hell?
No, the run up doesn't. But when you look at it, that's why I would have taken care of it if I was his attorneys and argued it was not part of the events. That they become the aggressors because he walks away. That takes care of the run up, in my opinion.
He said he was looking for little girl. He said he was looking for little girl.
I think they are. I think that's all part of it. I think that's what somebody would say.
I even have that part on camera.
And then they're probably trying to see if there's a punch, because that's going to be another thing.
We trying to have fun. If he's gonna claim you, he's gonna claim you. We don't want this motherfucker. Let it on camera. Let it on camera. He on camera. Oh God, he on camera.
I mean, it's like, look, there's nowhere for him to go in this instance. Boom.
He ain't a woman. He ain't a woman. You ain't a woman. He ain't a woman. You killed him.
That's where we're going to stop it. Yeah, thank you.
I agree with you, Jeff. That's why I said when he's flat out mischaracterizing
Everyone's good?
the video.
The jury or the bailiff will take you back.
But luckily, there's a video.
Deliberations.
So, guys, my prediction is a little different now. I think that we've seen this video now. I mean, they can't have it back in the deliberation room. I thought they would. We might have a verdict in the next hour or two. I mean, and that might be good or that might be bad. I mean, it just depends on. It looks like what they're looking at is the run up. So we'll see. Man.
Be seated. Mr. Anderson, anything for the record? No. Mr. Trofasi? No. All right, that's all. We're in recess. Do you have the jury list?
So there we go, guys. A little intel into the jurors' minds. Something you don't typically get unless you have a state that doesn't allow all the evidence to go back. That's unbelievable to me. Most of the time, most states would provide you with a laptop computer, and they would let them play that as much as they needed to and look at it as much as they needed to. It's evidence. It's in record. I don't know why they wouldn't let them do that, but I mean, maybe it's just not possible to get them the exhibits, I don't know. I don't know what the thought would be on that, but interesting. It'll be interesting to see what happens now following the playing of that video. So we'll see what happens. But man, I'll tell you, when you watch that video, what the hell world is the prosecutor living in that he could make the arguments that we heard? Like, that jury has to be sitting there going, what the hell is this prosecutor talking about? J9, yes, it would mean a hung jury. I don't think this will be a hung jury. I think that I think when they go back there, there's going to be some discussion. I think it's either there's a couple of stragglers on the guilty front, or there's a couple of stragglers on the not guilty front. And I think we're gonna know more. Now, if we get more questions about the law, I think that will start to tell us that they're considering lessers. But I really think for them, it's going to come down to, do you think it's self-defense or not? And I think there were some back there that were probably, the debate's going one of two ways. I think it's either going, he ran up on them, so it doesn't matter what he called them. He ran up on them first and scared them, so they were justified. They didn't, in other words, the pedophile talk and all that stuff was brought on by him because of him running up on the kids. And then on the other side, it could be, hey, he ran up on him, but then he walked away. So if he walks away, now he's no longer necessarily accountable for having run up. In other words, he's walking away, he's diffusing it, and then those kids are coming at him. But it looked like they wanted to see that. And I think they also wanted to see if they could see if she punched him or not. I'm sure there's people back there that are trying to figure that out, what exactly happened. But and then was he just stabbing people wantonly? What was he doing? I'm sure they were paying attention to little things like that. But I guess we'll see. Wow. So, anyways, I'm going to step away for a little bit here. I'll be keeping an eye on it in case the jury comes back soon. I've got to step away here at 4:00 and go do something my time, which is in about 40 minutes. Um, I agree with you. I think he was coming over. It looked to me like he saw the phone, although I think that's also what they're gonna see. Not guilty. I agree with you. You predict a hung jury. I know I wouldn't budge. Well, I hope that's what we have back there, because I cannot imagine 12 people view that video and that you would get 12 people to say he's guilty, or that it would be that quick. I think personally, the not guilties could win out here quick, or it could be an extended debate based on the fact that they're viewing this video so early. So. Yep. Well, thank you. Hallelujah. I appreciate you being in here watching. Like I said, I'm gonna keep it up, so it'll be up here. So if a verdict rolls and I'm for some reason out of the pocket, it's gonna come back. So let me switch to courtroom view, and I'll go into mobile view, and I'll be listening and watching on mobile. Hopefully, I could be in the box when this verdict comes back, because I think I'm now thinking maybe we have a verdict today. I don't know, but just based on what we watched, based on the fact that they don't have the video back there, it's I'm thinking now we might have a possibility. But anyways, all right, guys, I'll see you in a little bit. Hallelujah. Just want to say thank you for the super. I just saw that come through, and I was still by the computer. So I thought, you know what? I want to come up and say thank you very much for that. Very much appreciate it. Thank you so much. And like I said, I'll be back and talk to you soon here as soon as we have some more action. It sounds good. Yep, I will hopefully we'll be back today. And Jeff, yep, I'm predicting today as well. Thank you guys.
Please be seated. We are back in session. The attorneys are present. Mr. Miu is present. 12 jurors are present. Members of the jury, the bailiff has notified me that you would like to adjourn, go home, and then come back tomorrow morning. You're nodding your heads in agreement. That's your preference. That is your prerogative, so we will follow your wishes. The warnings tonight are the same as before. No independent research, no investigation about the case. Do not view any media reports, social media posts, internet commentary, or video about this case. Do not talk with anyone about the case either. It would be highly improper for anybody to attempt to influence your judgment at this stage, or any stage for that matter, of these proceedings. The bailiff will take you out. Let's come back tomorrow morning at 8 o'clock. Okay, 8 o'clock. Same routine as before. Please take the jury out.
All rise for the jury.
Please be seated. We're outside the presence of the jury. I do have another note. They are requesting to see the Cockfield video. Again, the exact wording is, can we see the Cockfield video tomorrow morning from 10 seconds before the confrontation with Maddie Cohen to 2:27 seconds, signed by the foreperson. Comments, Mr. Anderson?
No objection.
All right, since there's no objection, we will plan for that. As soon as the jury arrives, we'll assemble in the courtroom. I'd like to have the video connected and ready to go, and then we'll follow the same procedure as we did earlier today. No comments, no commentary, no opportunities to persuade or influence the jury. They're simply coming in to view the video, and then they will return to the deliberation room.
Do we agree that it would start then at 1:40?
I don't know what the time would be. They're just asking for 10 seconds before the confrontation with Maddie Cohen. So I'll let the attorneys identify what point in the video that is, and then we'll display that to the jury. Beg your pardon?
I would, maybe you don't want us to talk about it right now, so I was
Yeah.
going to talk, but
Yeah, you guys can figure that out, where in the sequence it should start from. Anything else from the defense?
no objection.
All right. Have a good night, everyone.
Can I approach?
Yes, we'll see you tomorrow.
Jury, as I will try to remember to tell you each and every day, or when we leave breaks, longer breaks, please do not discuss this case amongst yourselves or with anyone else. Please don't do anything to investigate this case. If you see any media coverage of the case, please try to avoid that so you can remain impartial. And with that in mind, that will conclude our first day of evidence. So we'll allow the jurors to be excused at this time. All rise, please. Thank you. Please be seated. Detective, if you want to go ahead and